Hello, welcome to Requiro. Today we are going to be talking about updates in Luigi Mangione's case. Now, you're probably thinking, but Meg, you made a video 2 weeks ago talking about updates in Luigi Mangione's case. Now, that video was me going over the updates from December 2025 all the way until January 2026. And this video is just me going over all the updates from February all the way until April 2026 in Luigi Mangione's case. I just had to play catch up. Anyway, you guys can probably notice I got a new microphone. And if you guys watch my little shorts and stuff or follow me on social media, you know the story behind it. Also, I attached a little bow on it to make it at least a little bit different because rainbow microphone was fun and sadly it died and I wanted something different, so I will figure out how to decorate this and make it look fun compared to a basic white microphone. If the audio is a bit off, I'm still trying to figure out everything with my new microphone and all that. I do apologize, this video came out a lot later than expected. I was fully intending to make this video on the Easter weekend. I normally don't celebrate Easter, but this year I had to do the family stuff. So I literally had no time in the span of the 4 days Easter long weekend. I do apologize about that, and then my microphone died and stuff like that, and anyway, so sorry this video came out a lot longer than expected. So, sorry about that. It was not my intention. Here are some updates in Luigi Mangione's case. We will cover in more detail later on in the video, but I just want to bring them up here anyway. So basically, on the 1st of April 2026, Luigi Mangione appeared in court again, and I did mention that in my last video they were going to have Luigi Mangione appear in court again to reschedule the trial date that was set by Judge Garnett, because Judge Carros set his court date right in the middle of the jury selection for the trial date set by Judge Garnett. And I've noticed this, some people have been getting a little bit confused between the state case and also the federal case, and again, it's very confusing, a lot of numbers floating around and stuff like that. There's a reason why I kind of stick with the judge's name, then instead of saying federal and then state case. I think it makes it a little bit easier who was deciding what by just saying the judges in the case instead of state or federal case in this case. So basically, some people have been muddling up saying the trial date that was set by Judge Garnett has been moved, but in reality, no, it hasn't. It is been the trial date that was set by Judge Carros has been moved back by, not by much, but by a couple of months. Again, we'll go over that in a lot more detail later on in the video, but I just thought I should put this here anyway. And another thing that also happened, it isn't really relevant to Luigi Mangione's case, but then kind of is, because Pam Bondi decided to get her hands involved in Luigi's case for no reason. Basically, on the 2nd of April 2026, Pam Bondi was fired by Donald Trump. We will go over this in more detail later on in the video, but when I heard that news, I was honestly surprised of wow, Donald Trump fired his lapdog, oh my god. Anyway, we'll cover that in more detail. Again, it isn't really relating to his case, but then also is at the same time. And all the information and all the sources I used in this week's video will be up on the website on this week's episode if you guys want to go check it out. And if there's anything I got wrong or anything like that, please let me know in the comments down below, and I'll sure to pin it or bring it up in my next video. I am human, I do make mistakes, I am one person working on all these videos. There is still no team because you see how big this channel. Now, let's get into the video. Hi, it's voiceover me. So I totally forgot to do this like I do in all my videos when I cover over the most recent updates in Luigi Mangione's case, but I haven't done it in a hot minute. So this is all the current information in Luigi Mangione's case as me filming this video on the 13th of April 2026. The 3rd of February 2026. a couple of documents came out on this day, and this first document I'm going to show you guys, it is a official document from Judge Garnett about her scheduling for Luigi Mangione's trial and everything in between. So I'll pop it up on the screen for you guys.
United States District Court, Southern District of New York, USDCSDNY document electronically filed doc, date filed, the 2nd of March 2026, United States of America v. Luigi Nicholas Mangione, 25 CR 00176, MMG, Scheduling Order Defendants, Margaret M. Garnett, United States District Judge, as discussed at January 30, 2026 conference. The schedule for jury selection, pre-trial materials, motions and appearances shall be as follows. April 13, 2026. Parties to exchange proposed questionnaires and confirm. May 4, 2026. Parties to submit their proposed questionnaire, to the court. May 11, 2026. Parties to file objections, if any, to each other's proposed questionnaires. May 26, 2026. Oppositions to objections due June 11, 2026. Court to provide proposed final questionnaire to counsel June 15, 2026. Conference at 11 a.m. to discuss final questionnaire and jury selection process June 16, 2026. Government to disclose any expert witnesses to defendant, pursuant to Rule 16, 1, G week of June 29. Jury Department to administer written questionnaire to prospective jurors in a venire of approximately 800. Government to scan completed questionnaires each day and provide to court and defense counsel July 16, 2026. Defense to disclose any expert witnesses to the government July 17, 2026. Parties to exchange lists of jurors to be struck for cause based on questionnaires alone and lists of jurors that require follow-up questioning regarding questionnaire answers. July 22, 2026. Parties to confer and submit a list to the court of jointly stipulated proposed strikes for cause and joint proposed list of jurors who require follow-up questioning regarding their questionnaire answers, as well as separate lists, if necessary, of any additional jurors that only one side seeks to strike for cause or requests follow-up questioning. July 31, 2026 at 11 a.m., conference to rule on stipulated and requested strikes for cause. List of venire for in-person questioning finalized and provided to Jury Department for notification regarding in-person voir dire August 4, 2026. Motions in limine due, including any but challenges, August 18, 2026. Oppositions to motions in limine due. The court generally does not permit reply on motions in limine. August 25, 2026. Proposed voir dire, requests to charge, and verdict form due September 2, 2026 at 11 a.m. Final pre-trial conference, September 8, 2026 at 9:30 a.m. In-person voir dire begins, October 13, 2026. Opening statements. The presentation of evidence begins, in accordance with the court's individual rules and practices for criminal cases, available at http://nisd.uscouts.gov/judge/Garnett. Parties should not submit courtesy copies of any submissions, unless the court orders otherwise. The proposed voir dire, proposed jury instructions, and proposed verdict forms must be emailed, in Microsoft Word format, to Garnett NISD Chambers, at nisd.uscourts.gov and so ordered. Dated, February 3, 2026. New York. New York. Assel Margaret and Garnett, United States District Judge.
This is another document saying Luigi Mangione's unavailability to appear in Pennsylvania court to deal with the charges there, because, Luigi Mangione is busy in New York. Please take this document with a little bit of skepticism. I did get it from Instagram, so I'll pop this document up on screen for you guys.
The 30th of January 2026 Notice of Defendant's Unavailability for Personal Appearance and Pre-Site Consent for Appearance. Blair County District Attorney's Office. The 2nd of March 2026 E-Service Served Dickey, Thomas M. The 2nd of March 2026 E-Service Served Blair County District Attorney's Office.
6th of February 2026. A couple of documents did come out on this day. There's a lot of birds outside. Can I keep talking about this, please, birds? So on this day, basically Luigi Mangione appeared in court again, but this is when Judge Carros set his trial date for Luigi Mangione. That was set right smack bang in the middle of the jury selection questionnaire for the trial date that was set by Judge Garnett. And this is also when we got a quote from Luigi Mangione. We have not heard a quote from Luigi Mangione in a very long time. I think last time we heard a quote from Luigi Mangione was from when he yelled right outside of the courthouse in Pennsylvania, if you guys remember that.
As completely out of touch and as insult the intelligence of the American people and the lived experience.
Not including the little statement he did on his website towards his supporters. We're not on about that. And this is the quote Luigi Mangione said directly towards Judge Carros when he was being led out of the courtroom after this decision was made. 1 + 1 = 2. This is double jeopardy from all common sense. I 100% agree with Luigi Mangione. If you guys remember around the time, I did make a post about it, and oh my god, this is fucking infuriating. And you can clearly tell as we go forward, especially in this case, you definitely see the double jeopardy and unfairness going on that none of these judges are taking seriously, except maybe Judge Garnett. She's pretty chill compared to Judge Carros, that's bluntly making things harder. And basically Judge Carros 100% can see this is double jeopardy going on, and they are literally using it against him, and it's bluntly unfair, and they fucking know it's double jeopardy. It's bluntly obvious, and the bias towards Luigi Mangione by Judge Carros is bluntly obvious and so unfair. And basically the trial date that was set by Judge Carros was on June 8th, 2026 in Luigi Mangione's case by Judge Carros. Again, like I said earlier, that is smack bang right in the middle of Judge Garnett's jury selection questionnaire. Again, we will go over that in a lot more detail of basically how fucking unfair this entire thing is. Like, two people can't be in one place at once. As much as we wish we could, we can't. I love when I read my notes, and I'm a lot more calmer and chill when I'm filming some days. I can tell I'm like insanely mad when I'm like writing my notes, and I'm just filtering myself right now after reading my notes. I think that's kind of hilarious. And we got a statement from Karen Arcafillo outside of the courthouse after Luigi Mangione had his court appearance on this day. And funny enough, I could not find this little clip or anything like that anywhere else other than like Instagram and Reddit. I find a little bit odd, but this is a statement from Karen Arcafillo, so I'll pop it up on screen for you guys.
All I will say is double jeopardy is meant to protect people, and they're using it as a weapon here. So it's unfair.
Double jeopardy is 100% going on in this case, and it's bluntly obvious Judge Carros does not give a shit and decides to do whatever he wants anyway because, he doesn't like Luigi Mangione or Karen Arcafillo. You can clearly tell when we read documents and stuff in this case. He has a little bit of bias towards him, and that's bluntly unfair. You shouldn't be biased, especially if you are a judge, I think, because you are deciding people's fates. Now, I do have this in my notes, so basically I originally thought I did find the original transcript for this court hearing, but I did look into it, and it is in the Free Luigi subreddit. Now you know my little bit beef with them about the transcripts only being on there, but I did look into it further, and I could not find the official transcript anywhere for this court date for Luigi Mangione's case. Only on the Free Luigi Mangione subreddit. I even did a reverse search on this as well on pages that were from the Free Luigi Mangione subreddit. They did not link where they got this transcript or anything like that anywhere. The only thing I could actually find of maybe a transcript of this day was by a news network. The script isn't from the actual official courtroom itself, it was just the transcript from the actual news reporter. So I am very skeptical about it. I generally thought I did find it, but it's only from the Free Luigi subreddit, and I could not find it anywhere else. Like I said beforehand in the when I was going over the live tweets, and I did ask where they did find their transcripts, and then they said they bought them from the court reporter and shared it for everyone to see on the Free Luigi Mangione subreddit, and I could not find them anywhere to purchase them for myself, so I could do it for a later time or tell you guys to go read them or pay for them, but I could not find them anywhere. So again, I am a little bit skeptical about it, that's all. Because, you know, normally when we get information in Luigi Mangione's case, like documents and stuff, they are posted everywhere, not just in one subreddit. So, again, this isn't me sending hate to the people who run the Free Luigi Mangione Reddit, I'm just a little bit skeptical about it. That's all. Because, you know, I can't find it anywhere else, but it's magically just in that one subreddit, but nowhere else. And people can make shit up, it's the internet, and I'm a little bit skeptical about it. Again, no hate to them. If this is the official transcript and all that is on the Free Luigi Mangione subreddit, you can tell me in the comments down below and say, you're wrong! I will eat my words and apologize profusely, but no one has done that yet. But if you guys want to go read them, I will put it up on this week's episode on the website. Ooh, I did make a little video about this on my social media and stuff like that. I was reading over the live tweets for this day, and then halfway through it switched to like April 1st, 2026 of the live tweets from the Luigi Times. I do recommend to go follow them. They do screenshots of the live tweets and then post it out for everyone to see, so great job, thank you so much. I relied on you 100% on when I was doing the December suppression hearings. Thank you, you're like the only thing that was coming out at the time, until hopefully one day we'll get the official transcripts for the December suppression hearings. Hopefully one day. We'll see. Anyway, so I was reading over the live tweets for this day, and I'm not going to use them for this day particularly, just because I was reading it and it was not very helpful to show you guys, because again, just only important words appeared here and there, and it wasn't very helpful to give you guys an idea what was going on in the actual courtroom. So I'm not going to use them for this part of the video. If you do want to go read them, they are going to be on the website linked if you want to go read them as well. February 6, 2026. Why is that so hard to say? I think it's because there's 2 6s in the same sentence for me. Anyway, but a massive thank you for the Luigi Times on Instagram for typing these up and taking screenshots and popping them up on Instagram for everyone to see and read, because sadly on Twitter, when you post things on the day of and then later if you want to go find it, it does get scrambled. I don't care, it's called X, okay? It's Twitter, it's been Twitter forever, okay? I don't care, Elon Musk. Thank you for them for doing that, but I will be using the live tweets on April 1st. 2026, but we'll go there later on in the video when we get there. This is a letter addressed to Judge Garnett by Karen Acapillo, basically talking about the conflict of the trial date set by Judge Carros, telling Judge Garnett, saying, hey, we need to organize something. This is a double jeopardy basically, and this is the reasons why this is a conflicting with the trial date set by Judge Garnett. I do want to say this here, basically in this document it does say July 1st for the trial date that was set by Judge Carros, but again this was in this official document, but later on it did get moved to June 8th, 2026. So again, we'll go over that later on in the video, and then it got moved again, so I'll pop it up on screen for you guys. Hi, it's VoiceOver Me. So if you go onto Luigi Mangione's official website where his legal team pop all the documents for his case and all that on there, it does say for this document it was on February 5th, 2026, but I just didn't realize and I marked it as February 2026, but it is stamped as it's been officially filed on February 6th, 2026. I do apologize about that, but I'm still going to leave it here in this lower section. I do apologize. Sometimes when I go through and organize and do my notes for this, it is a little bit scrambled or I miss things and stuff like that. And this document, when I was going over Luigi Mangione's case, was a lot longer than it normally is. So sorry about that.
Via mail, the Honorable Gregory Carros, Supreme Court of the State of New York, 100 Center Street, New York, New York 10001 Re. People vs. Mangione, IND, number 75657, 24. Dear Judge Carro, T. We write in response to the District Attorney's Office's January 28, 2026, letter requesting that this matter be set for trial on July 1, 2026. As set forth below, the people's request is both unreasonable and impracticable and should be denied. Most critically, Mr. Mangione is already scheduled to begin the jury selection process in his concurrent federal trial during the week of June 29, 2026, pursuant to the following scheduling order issued by United States District Judge Margaret Garnett, April 13, 2026, parties to exchange proposed questionnaires and confer, May 4, 2026, parties to submit their proposed questionnaire, to the court, May 11, 2026, parties to file objections, if any, to each other's proposed questionnaires, May 26, 2026, oppositions to objections due, June 11, 2026, court to provide proposed final questionnaire to counsel, June 15, 2026, conference at 11:00 a.m. to discuss final questionnaire and jury selection process, June 16, 2026, government to disclose any expert witnesses to defendant, pursuant to Rule 16, L.G., week of June 29. Jury Department to administer written questionnaire to prospective jurors in a venire of approximately 800. Government to scan completed questionnaires each day and provide to court and defense counsel, July 16, 2026. Defense to disclose any expert witnesses to the government, July 17, 2026. Parties to exchange lists of jurors to be struck for cause based on questionnaires alone and lists of jurors that require follow-up questioning regarding questionnaire answers, July 22, 2026. Parties to confer and submit a list to the court of jointly stipulated proposed strikes for cause and joint proposed list of jurors who require follow-up questioning regarding their questionnaire answers, as well as separate lists, if necessary, of any additional jurors that only one side seeks to strike for cause or requests follow-up questioning, July 31, 2026 at 11:00 a.m., conference to rule on stipulated and requested strikes for cause, list of venire for in-person questioning finalized and provided to jury department for notification regarding in-person voir dire, August 4, 2026. Motions in limine due, including any Daubert challenges, August 18, 2026. Oppositions to motions in limine due. The court generally does not permit reply on motions in limine, August 25, 2026. Proposed voir dire, requests to charge, and verdict form due, September 2, 2026 at 11:00 a.m. Final pre-trial conference, September 8, 2026 at 9:30 a.m. In-person voir dire begins, October 13, 2026. Opening statements. The presentation of evidence begins. United States v. Mangione, 25 CR 176, MMG, DKT 105. The 2nd of March 2026 Scheduling Order. This scheduling order establishes that counsel will be actually engaged and orders an extensive, multi-month jury selection process, including the review of 800 jury questionnaires, exchanges of strikes for cause, motion practice and pre-trial proceedings, culminating in in-person voir dire beginning September 8, 2026, and opening statements on October 13, 2026. Notably, the jury questionnaire review process that starts the week of June 29, 2026, will be a long and detailed undertaking that will take several weeks to complete which is precisely why Judge Garnett has provided counsel until July 17, 2026, to complete our review before exchanging a list of potential jurors to be struck for cause with the government. Given the amount of time required to conduct this questionnaire review process, it would be impossible for counsel, at the same time, to start the state murder trial on July 1, 2026. Among other issues, the federal jury selection process would be prejudiced by potential jurors in the federal case being exposed to press reports on the trial in the New York County case. Also, forcing counsel to begin the state court trial on July 1, 2026, would make effective preparation impossible and would violate Mr. Mangione's right to the effective assistance of counsel guaranteed under the federal and New York state constitutions. This is particularly true in this case given that counsel and Mr. Mangione are still in the process of reviewing the more than 7 terabytes of discovery that the defense has received from the prosecution. 2-1. While questionnaires vary in size in federal court, counsel expects the questionnaire in this case to be extensive given the extreme pre-trial publicity of this case. 2. The prosecution itself has emphasized the unprecedented scope of the investigation, multiple NYPD units, federal agencies, and extensive forensic and digital evidence. That complexity confirms that careful, deliberate preparation is required. Courts routinely hold that voluminous discovery and complex prosecutions justify extended preparation time. See People v. Spears, 64 NY, 2D 698, 699, 1984. Continuance appropriate where defense requires time to prepare in complex case. People v. Foy, 32 NY, 2D 473, 476, 1973. Trial court must ensure reasonable opportunity to prepare. Moreover, the prosecution's request for a July 1, 2026, trial date ignores the fact that jury selection in the state case itself will be lengthy given the extraordinary pre-trial publicity. Following jury selection, the defense anticipates a lengthy trial as the prosecution has noticed 15 different experts relating to forensic pathology, DNA analysis, latent print development/DNA trace evidence analysis, latent print comparison, primer gunshot residue and trace evidence recognition and collection, ballistics, firearm examination, identification, and operability, ballistics, microscopic examination and comparison, crime scene analysis and document fraud, counterfeit, fraudulent, or forged New Jersey driver's licenses. We expect the prosecution will also attempt to establish law enforcement's entire investigation from the alleged December 4, 2024, shooting through Mr. Mangione's December 9, 2024, arrest in Altoona, Pennsylvania. As we recently experienced, the suppression hearing alone consumed nearly 3 weeks. This trial will take several months, not weeks. Attempting to commence such a lengthy trial on July 1, 2026, would directly conflict with the federal trial schedule and render adequate preparation impossible. In addition to a firm federal trial date, another reason for the federal trial to proceed first is that it carries the more severe penalty. In federal court, Mr. Mangione faces a maximum sentence of life imprisonment without parole. In federal court, he is charged with 2 counts of stalking in violation of 18 U.S.C. Section 2261A, L, A, and A, 2A, for allegedly stalking, shooting and killing Brian Thompson on December 4, 2024, in Manhattan, pursuant to 18 U.S.C. Section 226L, B, L. Mr. Mangione would be facing the maximum penalty of life for allegedly causing the death of Brian Thompson. Because there is no parole in the federal sentencing structure, a sentence of life in prison means life imprisonment with no chance of release. By contrast, the top charge in the state matter carries a sentence of 25 years to life with the possibility of parole. Where one prosecution exposes the defendant to mandatory life imprisonment, it is plainly unreasonable to require that he disrupt that schedule, which has already been set, to accommodate a competing arbitrary state timetable. The district attorney's office asserts that state interests would be unfairly prejudiced by an unnecessary delay of this important matter until after defendant's federal trial. The 28th of January 2026 letter at 2. Far from delaying any proceeding, the defense here has proceeded apace to 1. Convince this court to dismiss the terrorism counts, 2. Convince the federal court to dismiss the federal murder count and firearm count as well as the death penalty as a potential punishment, 3. File scores of motions in both cases, and 4. Litigate 3 weeks of suppression hearings in this court. Moving forward, the defense will continue to proceed without delay to meet the schedule set by the federal judge, will try the federal case and will then proceed without delay to litigate this case. Furthermore, even where there is no concurrent federal case, a 2-year period between arrest and trial in a murder case is far from excessive. See, for example, People v. Pedro Hernandez, more than 2.5 years from arrest to trial in the Anton Patz case. People v. Nicholas Brooks, more than 2.5 years from arrest to trial in the murder of Sylvie Cache at the Soho House in 210. Cf. People v. Pamela Butchbinder, nearly 5 years between arrest and plea where the defendant was charged with the attempted murder of her former boyfriend. People v. Alex Ray Scott, more than 4.5 years between arrest and plea where the defendant was charged with murder of an acquaintance. The District Attorney's Office has also failed to show any prejudice it faces by the federal case proceeding to trial in accordance with the federal trial schedule. The defendant has speedy trial rights in both jurisdictions, and he is prepared to proceed to trial on the federal case consistent with the order already entered by the federal court. In addition, this is not a case that depends on elderly or infirm civilian witnesses, or indeed on civilian witnesses at all. Rather, the core of both the federal and state cases is the testimony of law enforcement officials and forensic evidence. To the extent that the public has an interest in the swift resolution of criminal cases, that interest is fully realized by commencing the jury selection process in the federal case in just over 2 months from now. In court on December 18, 2025, the District Attorney's Office noted that Mr. Thompson's elderly mother is waiting for trial to know whether Mr. Mangione is the one who allegedly committed December 4, 2024, shooting. The 18th of December 2025 TR at 1475. That is not a valid reason to propose an unreasonable and unrealistic trial date that directly conflicts with a previously ordered trial schedule in the federal case where Mr. Mangione is facing life imprisonment. Furthermore, the District Attorney's Office does not hold a monopoly on fact-finding, and the question who allegedly shot Mr. Thompson can be adequately addressed at the federal trial that is currently scheduled. Finally, counsel must prepare potential defenses that are unique to the state proceedings and unavailable in federal court. Additional investigation, motion practice, and legal preparation are required. For these reasons alone, the defense cannot reasonably be ready by July 1, 2026. Had the people conferred with counsel regarding scheduling, this conflict could have been avoided. Instead, the present request was made without consultation, and after the federal trial was already set, creating an unnecessary and avoidable compression of the defense's preparation time. 3. The people's request appears driven not by necessity, but by rhetoric. Unnecessary and gratuitous characterization of this case as an execution, assassination, or terrorism do not bear on scheduling and only heighten the risk of prejudice. Courts have repeatedly warned that sensationalized proceedings threaten a defendant's right to a fair trial. Shepard v. Maxwell, 384 U.S. 333, 362-63, 1966. Heightened publicity counsels for greater preparation time, not less. For all of these reasons, the defense respectfully requests that the court deny the people's request for a July 1, 2026, trial date and set a schedule that affords constitutionally sufficient time to prepare.
I do want to bring this up here. So in this document, it does bring up the trial date that the prosecutors wanted to set on the 1st of July 2026, but Judge Carros chose the date on June 8th, 2026 for Luigi Mangione's trial date. I just thought I should put that here. Again, I think some people are getting a little bit lost and a little bit confused, of me included, of the scheduling and all that. Do you guys have similar brains to me where things are too similar and you get them muddled up? I don't know. I know it's a dyslexic thing. I think some people are getting confused and all that, so I just want to put that here. So, it says July 1st, 2026, they are not referring to the actual official trial date that was set by Judge Carros. Trial date the prosecution wanted. But in reality, Luigi Mangione's trial date that was set by Judge Carros is on June 8th, 2026. They bring up the document basically in a lot more detail than what I'm going to describe here. Basically saying, they bring up in the document basically and saying a lot of detail of basically how much this is conflicting was the trial date selected by Judge Garnett of what Judge Carros has done, because it is smack bang right in the middle of the jury selection questionnaire for Judge Garnett's trial date for Luigi Mangione, and literally no one can be in two places at once, and they bring up in quite detail in this document, and they basically show the scheduling conflict of like, hey, this is where Judge Carros' trial is happening, and this is when Judge Garnett's trial is happening, and this is the conflicting going on with the time schedule. They bring up basically neither Luigi Mangione and his legal team can be in two places at once. They also bring up in the document basically, and they also explain basically right after Luigi Mangione would appear and be a part of his jury selection questionnaire, he would have to go back to NDC, and he would not be able to bring any documents or anything like that for trying to be prepared for basically Judge Carros' trial date for Luigi Mangione. He would not be allowed to bring any of that stuff back whatsoever. Again, very much making it unfair for Luigi Mangione and his legal team to be properly prepared in this. They also bring up the jury selection questionnaire would roughly take about 8 weeks to actually go through and complete, because it's going to be very long and lengthy just because of how complicated this case is, especially with the media wanting to get involved and all that, and the fascination of people's interest in this case. It is going to take a long time for them to go through and thoroughly make a fair jury for Luigi Mangione. Like we already know, they're trying so hard not to give that to Luigi Mangione. And they basically bring up it's going to start on September 8th, 2026 and roughly end around October 30th, 2026, the jury selection questionnaire for Luigi Mangione. And they can't prepare, and be there in person for Judge Carros' trial date for Luigi Mangione, because it's in the middle of those very important questionnaire for the jury selection. They also bring up because of the fascination and interest and media attention in this case is so big compared to any other case before in the past, that they bring up in the document, and basically the jury selection would be tainted because they would see the trial going on that was selected by Judge Carros, and they would be influenced by the media or people post on social media and all that in Luigi Mangione's case, again spreading false information, or like we already know, the media is incredibly biased towards Luigi Mangione, and they'll say whatever against Luigi Mangione if it's true or not, like we already know, or they could be influenced by scrolling online and stuff like Instagram, TikTok, etc. And sadly, there are some accounts out there that are Luigi supporter accounts, or even just regular accounts that spread misinformation in Luigi Mangione's case instead of, double checking and making sure it's accurate information or not. And the jury selection, they would see that and be influenced by that to make their decision towards Luigi Mangione instead of doing it on the actual day itself when you're meant to. And they basically bring that up. This is why they need to basically nullify Judge Garnett's case, or basically move it to 2027, Luigi Mangione's trial date in this, just so they can be prepared for 2 trials instead of, dealing with this dumpster fire mess. Also bring up this is going to be very complicated, and the reason why they need to do a lengthy and thorough jury selection questionnaire for Luigi Mangione's case, just because how complicated this case is, because they're not going to be using a random stranger as a witness in this. The prosecution want to use about 15 different analysts in Luigi Mangione's case, and also including all the officers that arrested Luigi Mangione all the way back in 2024 on the 9th of December and all that, instead of, using a old lady as a witness or a random person. And it's going to be incredibly complicated, and that's why it isn't really normal jury selection, and that's why they need to do a thorough jury selection and questionnaire in this case, so people, don't get confused or muddled up in this case, because the prosecution want to use about 15 different analysts in this case for Luigi Mangione's case. That's why it's going to be very big and complicated. And then on top of that, of the media's fascination of this case as well, is also going to make this very complicated as well, ever since the beginning as well. They also bring up in the document as well, the prosecution will make this a long and lengthy trial compared to, say, a trial that would go for 6 weeks, because they bring up in the document as well, with the December suppression hearing, that was only meant to last a week, but the prosecution dragged that out for a solid 3 weeks in this case. So they definitely know the prosecution will not make this trial go on for, say, 3 weeks. They will definitely drag this out for like 3 months, they bring up in the document, and I do have a feeling they definitely would do that, because we've seen it before in the past. They will drag shit out. Like we already know, they turned that December suppression hearing into a mini trial for some reason. Like, maybe they don't have a leg to stand on, and they're worried if the backpack was thrown out, they would have nothing. But sadly, like we already know, Judge Garnett kept that backpack in for some reason. It was infuriating, honestly, reading that. Also bring up in the document, the trial date that was set by Judge Garnett is way more important compared to the trial date set by Judge Carros, because the trial date that was set by Judge Garnett is way more serious because Luigi Mangione, if convicted guilty, he would have life imprisonment without parole, compared to, say, Judge Carros' trial date, where he could have 25 years with parole, compared to, say, Judge Garnett's, that's way more serious without parole. Judge Garnett's trial date needs to go first compared to Judge Carros. They also bring up in the document all the charges they have excessively taken off Luigi Mangione in this case, like to convince the court to get rid of the terrorist charges against Luigi Mangione, convince the federal court to get rid of the federal murder charge against Luigi Mangione, and also the firearm charges against Luigi Mangione, and most importantly, the death penalty against Luigi Mangione. And the third one is file scores of motions in both cases. I don't know why it's like that. I literally just copied and pasted it from the document. And they also bring up as well, they also went through a lengthy suppression hearing that lasted about 3 weeks, and they don't want to push back or anything like that in Judge Garnett's trial or anything like that. They do not want to do that whatsoever. Or maybe push Judge Garnett's date to 2027. They also bring up as well in the document, it is absolutely excessive of basically the arrest of someone to basically have them trialed in the span of 2 years, compared to, this kind of stuff is meant to happen in the span of 5, not 2. And they also bring up on the 8th of December 2025, they bring up the prosecution want to make this a speedy and fast trial. They are using Brian Thompson's elderly mother as a excuse of the reason why they want this to be a fast and speedy trial, because Brian Thompson's mother wants to know if Luigi Mangione allegedly shot Brian Thompson or not. That's why they want this to be a speedy trial. By the way, I do want to add this here. The prosecution make it sound like Brian Thompson's a whittling old lady who's about 95 years old and she's running out of time. She's about 77 years old, guys. Brian Thompson's mom. My grandma's 84 years old and she's kicking fine. Like, she's fine. She still lives in her own house. They're not dying anytime soon, okay? Brian Thompson's mom isn't dying anytime soon, okay? Now, I do want to say this here. I'm not, being mean or disheartening towards Brian Thompson's family. They did lose a son, a father, etc. And I don't want to, dismiss them. Because, again, if you have a family member that sadly was murdered and you just want to know answers as much as possible. So I do get them wanting to know answers, and we do hear cases in the past where police don't tell the victims' families or anything like that of what happened to their loved one, But I do want to say this here, Luigi Mangione does deserve a fair trial, and again, they normally don't happen in the span of 2 years. It normally happens 5 or more for a trial date after someone is arrested, and it does not give the excuse of people wanting to know answers quicker and compared to actually doing a thorough actual job in this case. Because again, we've heard multiple times in the past where victims' families, they don't get answers for their loved ones right away, compared to, say, in this case where they're using Brian Thompson's mother as an excuse of this is the reason why we need to make this done and dusted as quick as possible, compared to like other cases in the past where the victim's family do not know what happened to their loved one for like years. So why is Brian Thompson's mother a priority compared to every other person out there where their loved one was murdered? Something to think about there. Again, it just sounds like the prosecutors are just using Brian Thompson's mother as an excuse. Again, she's 77 years old. She's not that old, guys. She's not on her last legs. She can wait. But it's more so them using Brian Thompson's mom as an excuse that is annoying me more so than them wanting to know answers, if that makes sense. They also bring up in the document as well, they should not use Brian Thompson's mother as an excuse of why they want this trial done and dusted in the span of 2 years instead of 5, because again, it's not a very valid excuse using Brian Thompson's mom as an excuse for the reason why they want this to go as quickly as possible. They also bring up in the document, basically, they need a full year to be prepared for the trial date for Judge Carros, instead of, being fully prepared for the trial date that was set by Judge Garnett, and be kind of prepared for the trial date set by Judge Carros. It is physically impossible and unfair to do that. They also bring up, basically, this is a scheduling conflict between judges. They both never communicated whatsoever between each other about this when they were meant to, and now they have a scheduling conflict now between Judge Carros and Judge Garnett. I don't know whose fault that is. I'm gonna say both of them in this. They also bring up in the document they are fully prepared to go forward for Judge Garnett's trial date, and wanting to go forward with that, they are fully prepared compared to, say, Judge Carros, because, they're not prepared for that. It was like smack bang right in the middle. Bring up in the document and ask the judge, can they please basically do not honor the request for the prosecution to have July 1st, 2026 selected for Luigi Mangione's case for the trial date, and move it to a different time so, it doesn't affect Luigi Mangione's constitutional rights. Close enough. I'm struggling hard with that word today. Oh my god. Like we already know, they sadly did not respect that, and Judge Carros and selected Luigi Mangione's trial date on June 8th, 2026. Again, bluntly unfair. Okay, so that was the end of my little notes of that document, and this is a screenshot from courtlistener.com. Normally I don't really do this. I did this in my last video going over dates in Luigi Mangione's case, just because there's been a lot of incredibly important information from those little screenshots and stuff from Court Listener in the little blurbs and stuff they do in Luigi Mangione's case compared to like other times where it's like a sentence or two. So I'll bubble up on screen for you guys.
Notice of filing of official transcript as to Luigi Nicholas Mangione. Notice is hereby given that an official transcript of a conference proceeding held on the 23rd of January 2026 has been filed by the court reporter/transcriber in the above captioned matter. The parties have 7 calendar days to file with the court a notice of intent to request redaction of this transcript. If no such notice is filed, the transcript may be made remotely electronically available to the public without redaction after 90 calendar days. Moya, Goretti, entered. The 2nd of June 2026, main document notice of filing transcript.
Oh my god, before when I was looking at the raw footage of the first clip I made, I didn't realize how fucking big this microphone is compared to me. I don't know what it is, if I'm just a short person, or this is a big microphone, or it's a mixture of both. I am 4'11" for reference, by the way. And I know that for a fact. The 7th of February 2026, the 7th of February 2026. This is a article with Karen Arcafillo in it. Normally I would leave this a little bit near the end of the video with like things aren't really relevant to his case but are relevant to his case, but I thought this was important because this is like the first time we've ever gotten a article from Karen Arcafillo in this case. She's probably done it before in other cases, but not so much in this case, because normally we would get a statement from Karen Arcafillo in front of the courthouse or a statement on his website, but nothing really like an article or interview like this. Now, I do want to say this here, this article was put behind a paywall, but some of the Luigi Mangione supporters walked away around it or maybe paid for it, but they went in and took screenshots and uploaded it on Reddit. So if you guys want to go read the article yourself, it is on Reddit. It's also going to be on the website if you want to go read it. So a massive thank you to that person who uploaded it on Reddit for everyone to read and enjoy. I did also take my own screenshots. They're just not as clear, and I took them on my phone compared to like my laptop. But if you guys have noticed, if you don't live in the US when this article was coming out, you would realize, oh, you don't have access to this article because you don't live in the US. I also had that problem, and other people overseas also would have had that problem. So a massive thank you to the person on Reddit who did that, and a massive thank you to this person on Instagram for actually DMing me the actual link to this article. For like some reason, when I tried to click the link outside of the little DM thing on Instagram, it will not let me access it because again, I live in Australia, not in the US. But when this person on Instagram DM'd me the article, I was able to actually like open the article itself and take screenshots of everything, because before, when it came out, no one actually took screenshots or anything at the time. And then a couple of days later, someone took screenshots. That's a lot more clearer and a lot more nicer compared to the ones I have, because I wanted to read the article later. But this, I'll show you guys the article and all that near the end of the video. I just thought I should put this here. But yeah, a massive thank you to you. I would not be able to read or see this article without you sending it to me. Thank you so much. I realize I've been mentioning this person a lot lately. They just send me articles and stuff and I read them and I go, oh cool, useful, thank you. So I'm not playing favorites. They just send me stuff. I'm like, oh, useful, thank you. The 9th of February 2026, a couple of documents came out on this day. So basically, this is a letter addressed to Judge Garnett about the scheduling conflict of what Judge Carros has done, where he set his trial date for Luigi Mangione right in the middle of when Judge Garnett is planning to have the jury selection in Luigi Mangione's case. Now, a couple of documents did come out on this day, but basically the two documents that came out on this day is one, the first was the letter, I'm going to show you that bit, and then the second document that came out on this day was the example, but I'm not going to show you the example because it's literally what I just showed you guys beforehand, and I don't want to repeat myself here. So I'm just going to show you the letter, and we're going to move on to the next document after that. So I'll pop it up on the screen for you guys.
United States District Court, Southern District of New York, USDCSDNY document electronically filed doc, date filed, the 2nd of March 2026, United States of America v. Luigi Nicholas Mangione, 25 CR 00176, MMG, Scheduling Order Defendants, Margaret M. Garnett, United States District Judge, as discussed at January 30, 2026 conference, the schedule for jury selection, pre-trial materials, motions and appearances shall be as follows: April 13, 2026, parties to exchange proposed questionnaires and confirm May 4, 2026, parties to submit their proposed questionnaire, to the court May 11, 2026, parties to file objections, if any, to each other's proposed questionnaires May 26, 2026, oppositions to objections due June 11, 2026, court to provide proposed final questionnaire to counsel June 15, 2026, conference at 11 a.m. to discuss final questionnaire and jury selection process June 16, 2026, government to disclose any expert witnesses to defendant, pursuant to Rule 16, 1, G week of June 29, Jury Department to administer written questionnaire to prospective jurors in a venire of approximately 800. Government to scan completed questionnaires each day and provide to court and defense counsel July 16, 2026, defense to disclose any expert witnesses to the government. July 17, 2026, parties to exchange lists of jurors to be struck for cause based on questionnaires alone and lists of jurors that require follow-up questioning regarding questionnaire answers. July 22, 2026, parties to confer and submit a list to the court of jointly stipulated proposed strikes for cause and joint proposed list of jurors who require follow-up questioning regarding their questionnaire answers, as well as separate lists, if necessary, of any additional jurors that only one side seeks to strike for cause or requests follow-up questioning. July 31, 2026 at 11 a.m., conference to rule on stipulated and requested strikes for cause. List of venire for in-person questioning finalized and provided to jury department for notification regarding in-person voir dire. August 4, 2026, motions in limine due, including any Daubert challenges. August 18, 2026, oppositions to motions in limine due. The court generally does not permit reply on motions in limine. August 25, 2026, proposed voir dire, requests to charge, and verdict form due September 2, 2026 at 11 a.m. Final pre-trial conference, September 8, 2026 at 9:30 a.m. In-person voir dire begins, October 13, 2026. Opening statements, the presentation of evidence begins, in accordance with the court's individual rules and practices for criminal cases, available at http://nisd.uscouts.gov/judge/Garnett. Parties should not submit courtesy copies of any submissions, unless the court orders otherwise. The proposed voir dire, proposed jury instructions, and proposed verdict forms must be emailed, in Microsoft Word format, to Garnett NISD Chambers, at nisd.escourts.gov and is so ordered. Dated, February 3, 2026. New York. New York. Assel Margaret and Garnett, United States District Judge.
Basically, the prosecution sent a letter to Judge Carros requesting can they set their trial date for Luigi Mangione on July 1st, 2026, but Judge Carros selected July 8th, 2026. Like we already know, it is smack bang right in the middle of that. It's brought up in the document they very much agreed on in 2025. It doesn't say what date, but they agreed on in 2025. Judge Garnett's trial will happen first compared to Judge Carros' trial. That would happen afterwards, and on December 5th, 2026. They bring up in the document basically in 2025 they did agree on Judge Garnett's trial will go first in Luigi Mangione's case compared to Judge Carros' trial will go first in Luigi Mangione's case. They made that decision in 2025. It doesn't say anywhere in the document when they made that decision, they just did. But they also bring up in the document as well on the 5th of December 2025, that's when they will organize a final date for Luigi Mangione's trial in 2026. And this is brought up in the document. Basically, the district attorney never stepped in and organized, saying, hey, there is a scheduling conflict, and instead of them talking to each other, that never happened, and basically now there is a scheduling conflict. Again, this scheduling stuff was not meant to be done by Luigi Mangione's lawyers or even the prosecutors. It was meant to be organized and talked by both of the judges in this case. Neither of them have done that, and now there is a scheduling conflict. And they also bring up in the document they were very much prepared for this to be one trial, not two, in this document. And they have this little added bit by Judge Garnett saying they'll reach out and talk to the United States government, aka the prosecutors, and so they can discuss this organizing conflict so they can go forward and they can talk about this matter further, so they can organize this instead of having a scheduling conflict. Basically, this document is from Thomas Dickey about basically Luigi Mangione's unavailability to appear in Pennsylvania. I'm a little bit iffy about it and not really going to show you guys just because it's a little bit iffy, because I came across this on Reddit, and when I was reading the description on Reddit, it said they got it from Twitter and that person got an email from, I think, Thomas Dickey's newsletter thing. I don't know, people can get emails of documents from Thomas Dickey's side of things I've heard. I don't really know, but again, I'm a little bit iffy about it, and that person said then they posted it on Twitter, and the person saw it on Twitter and then put it on Reddit. And if you look at the little stamp on the actual document itself, it says it was released on the 30th of January 2026, even if it's like very hard to see because, you know, stamps aren't that great. But in the Reddit post, it said it was released on the 3rd of February 2026. So it's a little bit iffy and a little bit all over the place, but I'll put it on this week's episode on the website. And drinking game of how many times I've said this video, that little section. I'm just a little bit iffy about it, and I'm not sure if it's real or not, just because of how iffy it is compared to every other document I source from Reddit, Instagram, etc., where it has a actual link where you can go actually see the document compared to this one here. But I just wanted to add this here anyway, just in case this is real. By the way, I think this might be my last cute spring, autumn outfit for the year, because it is getting colder now and my legs are really cold, so go back to my emo warm clothes and be cozy for the next 4 months. I live in a very cold state. The 10th of February 2026. This document is just basically one of Luigi Mangione's attorneys said they've moved firms. They still work for Luigi Mangione. Please don't panic and say, oh my god, Luigi's losing attorneys. He's not. This attorney just moved firms. He works somewhere else, but he still works for Luigi Mangione. He's just changed addresses. But I have redacted phone numbers, fax machines, and all that personal information and all that in this document. I don't know why they still have fax machines. Why won't they let them die? Oh my god. Anyway, I'll pop it up on screen for you guys.
United States District Court, Southern District of New York, United States against Luigi Mangione, plaintiff. Case number 25 CR 176, defendant. Notice of change of address to Attorney Services Clerk and all other parties. I have cases pending. I have no cases pending pursuant to Local Rule 1.3 of this court. Please take notice of the following attorney information change. S4. Elin Schulman, fill in attorney name. My state bar number is 4,319,562. My SDNY bar number is ES9955. I am an attorney, a government agency attorney, a pro hac vice attorney. Firm information include full name of firm, old and new, address, telephone number and fax number, old firm, firm name, redacted firm address, redacted firm telephone number, redacted firm fax number, redacted new firm, firm name, redacted firm address, redacted firm telephone, redacted firm fax number, redacted. I will continue to be counsel of record on the above entitled case at my new firm/agency. I am no longer counsel of record on the above entitled case. An order withdrawing my appearance was entered on by judge dated February 9th, 2026. Elin Schulman, attorney, signative.
Another document came out on this day, so basically the transcript on the 30th of January 2026 will be released unless otherwise they request it not to be released. So that came out on this day, so I'll pop it up on the screen for you guys. Again, with all these documents where they're transcripts or longer, like 50 plus pages long, I will make it its own dedicated video because I don't want these to be very long videos. I've done that, I'm sorry, but then I've also realized if you have a good fan base, they'll watch anything no matter how long it is. I've
In the United States District Court for the Southern District of New York, USA/plaintiff, S.V. Case No. Defendant, S. Notice of filing of official transcript. Notice is hereby given that an official transcript of a held on has been filed by the court reporter/transcriber in the above captioned matter. Redaction responsibilities apply to the attorneys of record or pro se parties, even if the person requesting the transcript is a judge or a member of the public or media. The parties have 7 calendar days from the date of filing of this notice to file with the court any notice of intent to request redaction of this transcript. A copy of said notice must also be served on the court reporter. If no such notice is filed, the transcript may be made remotely electronically available to the public without redaction after 90 calendar days. This process may only be used to redact the following personal data: identifiers, social security numbers, dates of birth, minors' names, and financial account numbers. See Federal Rule of Civil Procedure 5.2 and Federal Rule of Criminal Procedure 49.1. Parties wishing to request redaction of other information may proceed by motion. We certify that the foregoing is a correct transcript from the record of proceedings in the above entitled matter court reporter. Transcriber date.
I've scrolled on YouTube and I've seen people's live streams for like 6 hours and people have watched it, so like, I think I'm fine, but I try not to go over, 3 hours. But I do have exceptions. The 27th of February 2026, this is a letter addressed to Judge Garnett by the United States government. I'll pop it up on screen for you guys.
February 27th, 2026 via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, 10007 Re. United States versus Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Garnett, the government writes, in accordance with the court's instructions at the pre-trial conference on January 30, 2026, to inform the court that the Department of Justice will not seek interlocutory review of the court's order entered that same day, DKT 103, dismissing counts 3 and 4 of the indictment. Respectfully submitted, Sean S. Buckley, attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S/Dominic A. Gentile, June Ziang, Alexandra S. Messiter, Thomas John Wright, Assistant United States Attorneys, 212-637-2200.
And it's just saying, basically this document is just saying they won't push back on Judge Garnett's decision to get rid of the death penalty against Luigi Mangione, and also counts 3 and 4. They won't argue and say they want those back on the table. So on this day, officially the death penalty has been taken off Luigi Mangione, and also counts 3 and 4. And when I first heard the news, it was absolutely amazing. I was so excited. It's like, oh my god, this is amazing. And it's honestly great we have at least one non-biased judge towards Luigi Mangione, because honestly, through this entire case has been biased towards Luigi Mangione ever since those police officers stepped into that McDonald's. The 2nd of March 2026. Basically, this is a document from the prosecution wanting to suppress Karen Arcafillo's motion to suppress everything they allegedly found in Luigi Mangione's backpack, and also his statements he said to police before his Miranda rights were read to him. Oh god. It's so funny sometimes when it's like, I read these, I go, this is a suppression of a suppression of a suppression. It's a bit like that sometimes. It's kind of funny, but a little bit of a tongue twister at the same time. Anyway, so basically, I do want to say this here. Please take this document with a little bit of skepticism. I did get this from Instagram, and on the actual document itself, it says it's 106 pages, and the screenshots I found on Instagram are only like 3 pages of this document. And I did try to find this document so we can like read it and show you guys, even if I don't really like reading the documents from the prosecutors. I just want to keep all the accurate information all in one place. But the screenshots I found only are 3 pages of that document. Later on, we do go over Karen's response to this document from the prosecutors, so I'm just going to show you guys the 3 pages that I found anyway. If you guys do come across or have the link to what the prosecution's document is, please send it to me and I will like go over it and like maybe make a little video or something going over that document. Even if I don't like going over and talking about the prosecution's motions and stuff, because if you guys remember my notes from reading the prosecution's motion, I was very sarcastic in that entire video, because oh my god, that document made no goddamn sense. They were very much looking over the entire thing with rose-tinted glasses, and it looked like a child wrote it who was trying to get the word count so they can, post their essay need to get done at 12 o'clock at night, compared to, Karen Arcafillo's motions, when you read them and they make sense and they get to the point. And again, that's not just me being biased, it's just me like reading the 2 documents of like one document looks very much of like filler words and all that, compared to another document that's more serious, gets to the point, even if it is very, very long, if that makes sense.
Supreme Court of the State of New York County, Criminal Term Part 32 NY Ind. Number 75657/2024. The people of the state of New York. Respondent, against Luigi Mangione, defendant movement. Post-hearing memorandum of law in opposition to defendant's motion to suppress Joel J. Seidelman, Assistant District Attorney of Counsel, March 2, 2026. Supreme Court of the State of New York County, Criminal Term Part 32. The people of the state of New York. Respondent, against Luigi Mangione, defendant movement. Post-hearing memorandum of law in opposition to defendant's motions to suppress NY Ind. Number 75657/2024, March 2, 2026. Memorandum of law introduction. On the morning of December 4, 2024, defendant crept up behind Brian Thompson, a 50-year-old father of two, on a Midtown Manhattan sidewalk and shot him twice at close range. One of the bullets pierced Thompson's heart and liver, killing him almost immediately. After confirming that Thompson was dead, defendant fled the scene and succeeded in vanishing for several days despite investigators' extensive efforts to track down the perpetrator of this sensational crime. During that time, NYPD officers publicized images of defendant that they had managed to cull from surveillance footage, and 5 days after the shooting, police officers in Altoona, Pennsylvania, a small city about 250 miles from New York City, received a report that somebody who looked like the New York City assassin was at a local McDonald's. The Altoona officers had no forewarning that the perpetrator of this high-profile murder would appear in their jurisdiction, and they were skeptical of the report's accuracy. But when two Altoona officers responded, one of them immediately recognized defendant as the person depicted in the publicized images of the New York City shooter. After defendant showed the Altoona officers a fake driver's license, they proceeded, in deliberate and painstaking fashion, to arrest him on Pennsylvania charges for the fake license and process his arrest in accordance with Pennsylvania search and seizure law. During that processing, the officers conducted a limited search of defendant's backpack at the McDonald's and then a thorough inventory search of that backpack at the Altoona station house, where they documented every item, including the murder weapon, a silencer, ammunition, and various damning writings, in that backpack. At every step, the Altoona officers responded to this unexpected and alarming situation reasonably, and reasonableness is, of course, the ultimate touchstone of the Fourth Amendment. People v. Pena, 36 NY, 3D 978, 979, 2020, quoting Riley v. California, 573 U.S. 373, 381, 2014. But defendant nevertheless seeks suppression of evidence recovered from his backpack, largely on the ground that the Altoona officers did not follow New York search and seizure law in processing his arrest in Pennsylvania on Pennsylvania charges. That argument fails for 3 reasons. First, the Altoona officers acted reasonably in processing defendant's arrest in accordance with Pennsylvania search and seizure law, without regard for what New York search and seizure law might call for. See infra. IAIB. After all, the Altoona officers were unfamiliar with New York search and seizure law, nor could they be expected to familiarize themselves with that body of law in advance of defendant's arrival, which they had no way of anticipating. Nor could they be expected to know that, although they were arresting defendant in Pennsylvania on Pennsylvania charges, their conduct would be assessed under New York search and seizure law. There is thus no basis to use the exclusionary rule to sanction Altoona officers for conduct that they correctly understood to be lawful in their jurisdiction. Second, the extensive hearing record demonstrates that, even under New York search and seizure law, Altoona officers acted lawfully in processing defendant's arrest. New York's law of exigency justified their limited search of defendant's backpack at the McDonald's, see infra.ic. And New York's law governing inventory searches justified their thorough search of defendant's backpack at the Altoona station house, see infra.2. Third, even assuming, counterfactually, some legal problem with the search at the McDonald's and the inventory search, Altoona officers obtained a search warrant for the backpack, thereby establishing an independent source for recovering the backpack's contents, see infra.3. Defendant also seeks suppression of various statements he made to police officers at the McDonald's and to corrections officers during his subsequent incarceration, but all of those statements are admissible on a variety of grounds, which are detailed below in point IV. Defendant's motion to suppress should be denied in its entirety.
The 3rd of March 2026. This is a screenshot from courtlistener.com. I'll pop it up on screen for you guys.
Order as to Luigi Nicholas Mangione. On February 4, 2025, Mr. Moskowitz was appointed to represent the defendant at public expense as learned counsel in a capital case under 18 U.S.C. Section 3005, DKT, number 10. While Mr. Moskowitz has ably performed that function for the defendant, this case is no longer a capital case, CDKT, numbers 103, 113, and the defendant has retained counsel who are highly experienced and skilled. Accordingly, the court must evaluate whether the appointment should continue. Counsel for the government and for the defendant are hereby ordered to submit a letter to the court by Friday, March 6, 2026, stating their position on the question of Mr. Moskowitz's continued appointment at public expense. If the defendant is seeking to continue Mr. Moskowitz's appointment, his letter should state whether there is additional relevant information that ought to be conveyed to the court in an ex parte and sealed forum. Signed by Judge Margaret M. Garnett on the 3rd of March 2026. Garnett, Margaret, entered. The 3rd of March 2026. May document.
I remember when this was happening online and I was seeing a lot of Luigi supporters freaking out online, thinking Luigi Mangione's losing a attorney. In reality, no, that's not the case. This isn't going to affect Luigi Mangione. The person was hired on for Luigi Mangione's team because the death penalty was put on Luigi Mangione, and this attorney was a specialist in that, dealing with death penalty cases, and the death penalty is not on the table anymore for Luigi Mangione. This person's services is no longer needed for Luigi Mangione. His services is no longer needed, and he will be useful in other cases where the death penalty is still on the table for them. So this isn't going to affect Luigi Mangione's case whatsoever. He's just moving on to do other cases that involving the death penalty. I've been noticing a lot lately with like some of the Luigi Mangione supporters and information in Luigi Mangione's case with some people where they rush to read the document but they don't truly understand, and then they go online and talk about it, and then they all like freak out and don't actually read it and understand what it is, and then they all freak out. And I've noticed that a couple of times actually in Luigi Mangione's case, like when a lot of people thought Luigi Mangione was suicidal, but in reality, no, it wasn't. It was brought up by the prosecutors in their motion of them heavily implying Luigi Mangione could have been suicidal when that's not the case whatsoever. It was really weird. They were like on about that for a while in their motion, but in reality, a lot of people, I think they might have gotten confused, and then a lot of people must have saw that and thought Luigi Mangione might have been suicidal when he wasn't. I've been noticing that a lot lately. Some of these supporters see something and then don't truly understand and then say online about it. People see it and then get a little bit confused or don't quite understand it and then talk about it online and then freak out instead of like, taking a step back, take a breathe in, actually look into it and see, oh, okay, that's not what it means. Again, I'm noticing that a lot lately in Luigi Mangione's case where people do that, where like they haven't looked into things further, or they read something and they don't quite understand it, and then they go online and then freak out about it but yeah, it's okay. You need to take a deep breath in, take a step back, it's gonna be okay. The 5th of March 2026. This document is a motion submitted by Karen Rockefeller requesting can they have a little bit more time, but the attorney they hired on who deals with a lot of death penalties and all that, and that is a specialist, they're just busy somewhere else and they just need a little bit more time to confirm things with them. I'll pop the document up on screen for you guys.
Via ECF, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York 10007 Re, United States v. Mangione, 25 CR 176, MMG. Dear Judge Garnett, we write in response to this court's March 3, 2026, order directing the parties to submit a letter by March 6, 2026, to address whether Abby Moskowitz should continue as learned counsel at the public expense given that Mr. Mangione is no longer facing the death penalty. DKT 114, the 3rd of March 2026 order. We write requesting that this court extend counsel's letter deadline to March 12, 2026, as counsel needs to confirm with Mr. Moskowitz, who has been on trial in the Eastern District of New York for the past few weeks, but which is expected to end shortly. Additionally, because counsel's letter will detail Mr. Moskowitz's current and potentially future role in Mr. Mangione's defense, counsel seeks permission to file their letter ex parte and under seal. Thank you for your consideration. Respectfully submitted, Karen Friedman Anafilo.
And they just basically need to confirm a couple of things with him before they submit their letter. This is another document from Thomas Dickey just saying Luigi Mangione isn't available to appear in Pennsylvania because, he's busy in New York. Please take this document with a little bit of skepticism. I just got this from Reddit, so I'll pop it up on screen for you guys.
The 3rd of May 2026 order, determining the defendant remains unavailable for proceedings / see detailed order Blair County District Attorney's Office. The 3rd of May 2026 e-service Dickey, Thomas M. The 3rd of May 2026 e-service Bernard, Jackie Atherton served.
6th of March 2026, that motion I just showed you before has been granted, so basically they're allowed to wait a couple of more days so they can finalize things before they submit their letter. I won't show you guys the document because again it's exactly the same. The only difference is it has a little stamp saying it's been submitted and granted. 9th of March 2026, this is a letter submitted by the United States government. I'll pop it up on screen for you guys.
March 9th, 2026 via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, 10007 Re, United States v. Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Garnett, the government writes, in accordance with the court's March 3, 2026 order, DKT 114, regarding the continued appointment of the defendant's learned counsel, the government understands that defense counsel will address this issue separately in an ex parte submission. The government takes no position on the issue. Respectfully submitted, Sean S. Buckley, attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S/Dominic A. Gentile, June Ziang, Alexandra S. Messiter, Thomas John Wright, Assistant United States Attorneys, 212-637-2200 CC, Counsel of Record, via ECF.
The 13th of March 2026, this is a screenshot from courtlistener.com, and normally I wouldn't really show closed document screenshots that much, but this closed off document is from Karen Ocafillo, addressed to Judge Garnett, and a lot of speculation was happening about this because we haven't really seen that many documents sealed off by Karen Ocafillo. A lot of those documents are available for all of us to read, but please don't take this as fact. This is just speculation of what I think may be why they had this document sealed. So basically, I think they had this document sealed so the prosecution aren't able to look at it and see and get a foot ahead Luigi Mangione's legal team and do whatever they've been doing through this entire case, making everything 10 times harder towards Luigi Mangione and his legal team compared to when they can see documents and they just do a bunch of shit and make things harder for everyone else is set for them. But basically I feel like this document is them just trying to organize a way around of Judge Carros' decision of the double jeopardy that's obviously going on and the trial date set by Judge Carros with Judge Garnett if they decide to do something like this again in the future. So I think that's what this sealed document is about, but again, it's sealed off. We don't have access to it. It's just my thoughts and speculations about this. Again, I normally don't really do this speculation stuff, so please don't take this as fact. What I said here is just what I think it might be about, or it could be totally wrong. It could be about something entirely different entirely. Here's another document from Thomas Dickey saying Luigi Mangione isn't available to appear in Pennsylvania because, you know, he's busy in New York. But please take this document with a little bit of skepticism. I did get this off the internet. I don't remember where. I did not put this down in my notes for some reason.
In the Court of Common Pleas of Blair County, Pennsylvania, Commonwealth of Pennsylvania versus Luigi Nicholas Mangione, Defendant Hon Jackie Atherton Bernard Peter Weeks, Esquire Nicole Smith, Esquire Thomas Dickey, Esquire number 2024 CR 2724-2026 Car Presiding Judge 3 District Attorney CO 1st Assistant District Attorney Counsel for Defendant Order and now, this 5th day of March, 2026, entry of the following order is deemed appropriate. It is hereby ordered, directed, and decreed that 1. Pursuant to prior orders, the Commonwealth filed a notice of defendant's unavailability for personal appearance in the Blair County Court of Common Pleas and precite the consent to remote appearance notice on November 25, 2025, and January 30, 2026. 2. By prior court orders, the defense was required within 14 days of the Commonwealth notices to file a certification of record as to the defendant's prior demand for in-person appearance, or if he has reconsidered and will appear remotely, and or his ongoing obligation to update the court as to any change in the defendant's circumstances, making him available for proceedings in Blair County. 1. The defense has failed to file a certification following the Commonwealth's docketed on November 25, 2025, and the Commonwealth's notice docketed on January 30, 2026. Further, the defendant failed to advise of any change in his status which would make him available for proceedings in Blair County. Therefore, the court determines that the defendant remains unavailable for purposes of defending the case in Blair County. Further, the court deems the defendant's unavailability as a waiver of Rule 600. 2. Pursuant to the prior orders of court, the Commonwealth remains under an ongoing obligation to update the record in this court every 60 days on the status of the defendant's availability for proceedings in Blair County, Pennsylvania. Additionally, the defense is directed to advise in writing by filing a proper certification of record as to the defendant's demand for in-person appearance, or if he will appear remotely. Said certification shall be filed within 14 days of the Commonwealth's recorded update regarding the defendant's availability for transport. The defense also shall timely notify the court with a record filing of any change in the defendant's status, which renders him available for prosecution in Blair County.
I've broken down this document many times in different forms, many times, so I won't repeat myself doing it here. The 16th of March 2026, this is basically a reply from Karen Ocafillo to what the prosecution was saying in their motion wanting to suppress Karen Ocafillo's motion to suppress everything they allegedly found in Luigi Mangione's backpack and statements he made towards police. So I'll pop it up on screen for you guys.
Via email, the Honorable Gregory Carros, Supreme Court of the State of New York, 100 Center Street, Part 32, New York 10013 Re. People v. Mangione, IND. Number 75657, 24. Dear Judge Carro, we write to briefly reply to the prosecution's response to Mr. Mangione's post-hearing submissions. 1. The warrantless McDonald's search was improper. In Mr. Mangione's opening brief, counsel argued that the evidence recovered from Mr. Mangione's backpack should be suppressed because Altoona law enforcement's backpack search was not justified as a search incident to a lawful arrest, as a search for a bomb or an inventory search. In its response, the District Attorney's Office asks this court not to suppress the evidence recovered during the warrantless McDonald's search, because the exclusionary rule should not apply as it would not deter unreasonable searches and seizures to require Pennsylvania police officers to understand and apply a foreign jurisdiction's case law when conducting a search in Pennsylvania of a defendant arrested in Pennsylvania for committing a Pennsylvania crime. Response at 43. The prosecution further claims that suppression is not appropriate because Altoona law enforcement followed Pennsylvania search and seizure law reasonably and in good faith while carrying out an arrest in Pennsylvania for violations of Pennsylvania law, ID. These arguments fail. First, Patrolman Detwiller testified at the suppression hearing that he knew from the moment Mr. Mangione lowered his mask that he was the New York City shooter. from that this reply will only address issues raised in the prosecution's response relating to the warrantless searches of Mr. Mangione's backpack. Counsel relies on the arguments in Mr. Mangione's opening brief to address the issues related to suppression of Mr. Mangione's statements to the prosecution claims that the McDonald's search does not implicate the red notebook, which officers handled as they were feeling around the backpack for a bomb, but which officers never opened at the McDonald's. Response at 42N16. The record reflects, however, that Patrolman Fox did more house than the Ed Notebook in the ACAC. Te purposely emitted at 6 EL at 9 hours, 59 minutes, and 5 seconds. The prosecution is hard-pressed to argue that removing a notebook from a pouch that was inside a backpack is not a search. Moment. Altoona law enforcement knew that their actions would have consequences under New York search and seizure law because Mr. Mangione would ultimately be prosecuted in New York for an alleged murder that occurred in New York. This was certainly clear to Altoona law enforcement when Lieutenant Hanelli reached out numerous times to New York law enforcement while he was at the McDonald's. Consequently, the prosecution's claim that Altoona law enforcement cannot be expected to anticipate which state's search and seizure law will govern an interaction with a particular defendant ID, at 47, has no merit, as they knew while at the McDonald's that their conduct would implicate New York law. Altoona police officers were in near constant contact throughout the day with elite, experienced New York law enforcement experts who are intimately familiar with New York law, and who advised them. Thus, there was no need for them to have any knowledge of New York law. Second, law enforcement's actions at the McDonald's cannot be described as a reasonable and good faith application of Pennsylvania law. The hearing testimony established that it was Altoona law enforcement policy to search all bags when a defendant is arrested without consideration for whether the bag was in the immediate control of the defendant at the time of the arrest or what the defendant was arrested for. This is not a reasonable application of Pennsylvania law, which limits a search incident to a lawful arrest to the person arrested and the area within his immediate control. See, e.g., Commonwealth v. Williams, 305A, 3D 89, 97, PA, Super 2023. The search incident to arrest exception allows arresting officers, in order to prevent the arrestee from obtaining a weapon or destroying evidence, to search both the person arrested and the area within his immediate control. Citation and quotation omitted. See also Commonwealth v. Wright, 742A, 2D 661, 665, 1999. A warrantless search incident to an arrest is valid only if it is substantially contemporaneous with the arrest and confined to the immediate vicinity of the arrest. Quoting Shipley v. California, 395 U.S. 818, 819, 1969. Nevertheless, the prosecution argues that the search was a valid search incident to arrest because the backpack was in Mr. Mangione's possession when the police had probable cause to make the arrest, even though the backpack was no longer in his possession at the time of the actual arrest. In making this argument, the prosecution relies on an unpublished opinion from the Superior Court of Pennsylvania in Commonwealth v. Dunbar that noted that a search incident to a lawful arrest can be valid if the bag was in the defendant's immediate area at the time the police had probable cause to arrest him. Response at 5455, quoting and citing Dunbar, 2023 PA, Super, Unpub, Lexus 1637, Star 6, July 6, 2023. Notably, this case specifically notes that it is a non-precedential decision. Moreover, to the extent Dunbar would permit searches incident to a lawful arrest, even when the defendant's bag is not on the defendant's person or in the area within his immediate control at the time of his arrest. This decision is not consistent with Supreme Court precedent set in Chimmel v. California, 395 U.S. 752, 1969, United States v. Chadwick, 433 U.S. 1, 15, 1977, and Arizona v. Gant, 556 U.S. 332, 339, 2009, all cited in Mr. Mangione's opening brief, pages 49-51. Third, Altoona law enforcement's reliance on Pennsylvania law is irrelevant because, as argued in Mr. Mangione's opening brief, pages 38-39, New York search and seizure law applies where New York is the forum state, which it undoubtedly is here. In response, the prosecution argues that the numerous cases cited by Mr. Mangione are distinguishable because those cases only held that evidence was admissible in New York when it was properly obtained under New York law, but in violation of another state's search and seizure law. Response at 50-51. That, however, is a distinction without a difference, as the cases cited by Mr. Mangione unambiguously stand for the proposition that suppression issues, including those arising out of a defendant's constitutional rights, are generally governed by the law of the forum, and New York has a paramount interest in the application of its laws to this case. See, for example, People v. Espinal, 161 AD, 3D 556, 557 A Step 2018. This statement of law is true whether applying New York search and seizure law leads to suppression or whether it leads to admitting the evidence. Here, for all the reasons stated in Mr. Mangione's opening brief, applying New York law leads to suppression. The prosecution next argues that the warrantless search at the McDonald's was not improper because the officers were reasonably concerned that the backpack contained explosives. Response at 57. This argument is belied by the officers' own actions. As argued more fully in Mr. Mangione's opening brief, pages 54-57, the totality of the circumstances demonstrates that the officers' claim about a bomb was a blatantly false and pretextual justification for conducting an evidentiary search. For example, during this alleged bomb search, patrolwoman Wasser and patrolman Fox purposefully searched items that they knew could not have contained a bomb, such as a small bag containing Mr. Mangione's passport, an envelope, a wallet and a cardboard container admittedly too small to contain a bomb. 3. Moreover, law enforcement never cleared the McDonald's and instead allowed customers and employees to walk freely through the back area of the McDonald's where the supposed bomb would be located. Most tellingly, patrolwoman Wasser and patrolman Fox stopped their alleged bomb search once they found the gun magazine, even though they had not searched the entire backpack. For these and the other reasons stated in Mr. Mangione's opening brief, this court should find that the alleged bomb search was nothing more than a false and pretextual justification for an evidentiary search of Mr. Mangione's backpack. Similarly, the prosecution's claim that Altoona law enforcement was justified in searching the backpack because they were concerned that it contained a gun is meritless and not supported by the record. The evidence at the suppression hearing included hours worth of body-worn camera footage from 7 different officers. At no point in any of this footage is there any statement from any law enforcement member that they were searching the backpack because they were concerned that it might contain a gun. Instead, the only stated concern patrolwoman Wasser and patrolman Fox gave for searching the backpack at the McDonald's was to make sure it did not contain a bomb. Accordingly, as noted in Mr. Mangione's opening brief, page 57, the prosecution's argument in their response, the district attorney describes patrolman Fox as opening the cardboard as follows. Officer Fox then retrieved from the backpack 2 pieces of cardboard that were taped together, separated them, and found a piece of computer equipment inside. Response at 24. In reality, patrolman Fox took out a tactical knife and spent more than a minute trying to cut open the cardboard container that he admittedly knew did not contain a bomb. If this truly were a search for a bomb, patrolman Fox would not have wasted time trying to pry open a small cardboard container that he knew did not contain a bomb. About a gun in the backpack is merely a post hoc excuse that law enforcement advanced at the suppression hearing to attempt to now justify the warrantless search of the backpack. 2. The precinct searches were improper. The prosecution argues that patrolwoman Wasser's search of the backpack on a metal chair in the corner of the intake area of the Altoona precinct was proper. In making this argument, the prosecution ignores what everyone else in the courtroom, including this court, saw from her body-worn camera footage, as noted in Mr. Mangione's opening brief. She started her search by briefly unzipping then quickly rezipping the middle compartment of the backpack, which she had already searched at the McDonald's, but stopped looking through once she found the loaded magazine. Patrolwoman Wasser immediately closed the middle compartment and unzipped the front compartment, which she claimed to have not searched before. Instantaneously, patrolwoman Wasser found a loaded firearm clearly visible in the front compartment. Opening brief at 59. This conduct was not consistent with an inventory search and demonstrated that she knew where the gun would be located before she even opened that portion of the backpack. For this is also evident from the fact that patrolwoman Wasa started this search on a metal chair in a corner where there was limited space and no room to conduct an actual inventory search. She also started this alleged inventory search without any evidence bags or tags, despite knowing from her warrantless McDonald's search that the backpack was filled with a large amount of Mr. Mangione's personal property. The prosecution next claims that patrolwoman Wasa's continued search in the precinct hallway was a proper inventory search because she was separating evidentiary items from personal property. Response at 73. However, as the New York Court of Appeals has ruled, highly incriminating evidence may be a consequence of an inventory search, it should not be its purpose. People v. Johnson, 1 NY, 3D 252, 256, 2003. Here, as the prosecution admits, patrolwoman Wasa's hallway search was done with the specific intention of locating and separating out incriminating evidence. This intention was further demonstrated by the fact that patrolwoman Wasa did not catalogue any of the non-evidentiary items and just crammed them back into the backpack after she separated out what she believed was incriminating evidence. That is not a proper inventory search. In Mr. Mangione's opening brief, pages 61-62, counsel noted that patrolwoman Wasa had the opportunity to search the backpack in her car on the way back to the precinct. The prosecution retorts that it is difficult to fathom why, knowing that they would soon be able to lawfully search the backpack, they would first search it in secret on the side of the road. Response at 72. The answer is obvious. Patrolwoman Wasa wanted to be the one to get credit for finding the alleged murder weapon in a case that had captivated the country for nearly 5 days. That is also why she made sure that her audio was working on her body-worn camera before finding the gun on a metal chair in the corner of the intake area. The search in Patrolman Featherstone's office. The prosecution claims Sergeant Houston, Sergeant Burns and Patrolman Featherstone properly conducted an inventory search in Patrolman Featherstone's office and then the roll call room. Counsel will not repeat all the arguments made in Mr. Mangione's opening brief, pages 66-73, as to why this search was not a proper inventory search under the Altoona General Orders. Counsel will note, however, that to the extent the prosecution relies on Judge Garnett's finding that the search of the backpack at the Altoona Police Department was consistent with the written regulations and standard practices for an inventory search. Response at 83. Quoting Judge Garrett's decision, Judge Garnett conducted only a limited hearing relating to the parameters of the Altoona Patrol Guide and only analyzed the Altoona inventory procedures under federal law and not New York state law. Counsel will address the prosecution's claim that the officers properly read through Mr. Mangione's writings as part of the inventory process. As part of Mr. Mangione's opening brief, page 69, counsel argued that, even assuming the Altoona General Orders authorized an inventory search of Mr. Mangione's backpack, it would have only authorized officers to remove the journal from the backpack and note that a journal was recovered. It would not allow officers to read through the journal. The district attorney's office does not respond to this argument. Instead, the prosecution only responds, albeit ineffectively, to counsel's argument in Mr. Mangione's opening brief, pages 69-71, that reading Mr. Mangione's writing violated New York law. The prosecution claims that Mr. Mangione did not have an expectation of privacy in his journal because patrolwoman Wasa had already surveyed its contents in order to assess whether it should be processed as personal property or as evidence. Response at 79-80. This argument is puzzling on several levels. First, a review of patrolwoman Wasa's body camera footage demonstrates that Wasa flipped through the journal for less than 20 seconds, X6F, 2 at 10 hours, 22 minutes, and 51 seconds 10 hours, 23 minutes, and 9 seconds, before stating it's like a journal. She did not read through all the journal entries like Sergeant Houston and Sergeant Burns did. Second, to the extent patrolwoman Wasa read any part of the journal in those 18 seconds, she also exceeded her authority under the Altoona General Orders. The prosecution next tries to distinguish People v. Somerville, 170 miscellaneous 2D 1024, SCT, Kings CTY 1996, and United States v. Santos, 961 F sub 71, SDNY 1997, analyzed on pages 69-71 of Mr. Mangione's opening brief, by arguing that, in this case, The review of defendant's backpack's contents in Officer Featherstone's office and the roll call room yielded comprehensive documentation of every item in that backpack, regardless of any apparent evidentiary value. Response at 80. This argument deliberately misses the point. In Somerville and Santos, the courts suppressed the writings because the officers exceeded the parameters of a permissible inventory search by reading the contents to help with their investigation. That is exactly what Sergeants Burns and Houston did in this case, as they admitted at the hearing that they read portions of the journal because they believed those portions were relevant to the New York investigation. HR 1101-03. Sergeant Burns testified that he read some of the journal just out of curiosity, saw pages labeled blog and others with miscellaneous writings and photographed pages that he thought were relevant to the New York investigation. HR 1234-1235. Sergeant Houston admitting that he read some of the writings, including the journal, and photographed the pages of the journal that he thought might be pertinent to the New York investigation. Accordingly, Mr. Mangione's writings should be suppressed for the subsequent search warrant did not cure the illegal searches. The prosecution claims that whether the warrantless searches were proper or not, the backpack evidence should be admissible under the independent source doctrine because Sergeant Houston obtained a search warrant for the contents of the backpack at 6 p.m. on the day of his arrest, more than 8 hours after Altoona law enforcement started conducting the warrantless searches of the backpack. Response at 83-86. As the Court of Appeals has ruled, however, the presence of an independent source for a warrant and subsequent search does not automatically immunize an initial warrantless search and ensure the admissibility of evidence eventually seized pursuant to the warrant. People v. Burr, 70 NY, 2D 354, 362, 1987. This is certainly true in this case. The principal New York case addressing the independent source exception to the exclusionary rule is People v. Arnor, 58 NY, 2D 27, 1982. In Arnor, an undercover officer purchased cocaine from the defendant's apartment. While at the apartment, the undercover officer observed a large quantity of cocaine. 35 minutes later, officers entered the building and arrested the defendant. At that time, the officers did not search for evidence, and no evidence was discovered or seized. 40 minutes later, other officers responded to the scene to secure the apartment while officers met with the district attorney's office to prepare a search warrant application. The search warrant application reflected only information obtained from the undercover officer with respect to the type, quantity and location of the contraband which he observed in defendant's apartment, and anything observed by the officers upon their initial entry into defendant's apartment was mentioned in the affidavit. ID, at 30. Based on this warrant, officers searched the defendant's apartment and recovered a plastic bag of cocaine, a large amount of marijuana and a drug scale. In denying the defendant's suppression motion, the Court of Appeals noted that the evidence was obtained based on a search warrant that was based solely on information obtained prior to and independent of the illegal entry, namely, the undercover officer's observations from inside the apartment. ID, at 33. The Arnor Court further noted that the search warrant was obtained based solely on information obtained by the undercover officer prior to and independent of the illegal entry. ID. The court added, since there is not the slightest hint that the search warrant was in any way tainted by the illegal entry, or that the police exploited the entry in an effort to obtain evidence, we hold that the evidence seized is not the fruit of the poisonous tree and that the exclusionary rule is, therefore, inapplicable to this case. ID. The facts here are readily distinguishable. In Arnor, no search for evidence was conducted and no evidence was discovered or seized before the search warrant application LD at 30. Here, at the time of Sergeant Houston's search warrant application on December 9, 2024, at 6 p.m., Mr. Mangione's backpack had been searched several times, and its contents had been discovered and seized by Altoona law enforcement. Indeed, one of the stated purposes of Sergeant Houston's search warrant application was to seize the property that Altoona law enforcement had already seized during their warrantless searches. X12A at 3, affiant requests this search warrant to seize the items located during the search incident to arrest and inventory of Mangione's property. Additionally, unlike in Arnor, the search warrant in this case relied heavily on the warrantless searches that Altoona law enforcement had conducted hours earlier. In fact, as part of the basis for probable cause for the warrant, Sergeant Houston's search warrant application listed the property Altoona law enforcement had recovered through their warrantless searches, X12A at 23. Sergeant Houston even referenced the contents of Mr. Mangione's writings to establish probable cause in his search warrant application, ID. Consequently, in this case, there is significantly more than the slightest hint that the search warrant was in any way tainted by the prior warrantless searches. In support of their independent source argument, the prosecution argues that when police obtain a facially valid warrant after conducting an unlawful search, suppression is required only if the defendant demonstrates that procurement of the warrant was causally related to the illegal police conduct. Response at 84, citing Arnor, 58 NY, 2D at 32. The prosecution argues that Mr. Mangione cannot meet that burden here because the search warrant application supported probable cause even without the information from the warrantless searches. Specifically, the prosecution notes that Sergeant Houston's affidavit relied, inter alia, on information he had received from NYPD Detective Oscar Diaz. Response at 84, noting that Sergeant Houston had learned from NYPD Detective Oscar Diaz how those surveillance stills showed Brian Thompson's shooter, that he had learned from Detective Diaz about the markings on the shell casings from the shooting, about the victim's position as a health insurance CEO, and about the shooter's flight on a bicycle. Sergeant Houston only learned this information after the warrantless searches, as Arnor and other cases make clear. However, the subsequent warrant must be based solely on information obtained prior to and independent of the improper police conduct. Arnor, 58 NY, 2D at 33, emphasis added. See also People v. Silverstein, 74 NY, 2D 768, 770, 1989. The undisturbed factual determination of the suppression court that the warrant application was based solely on information obtained prior to and independent of the initial entry is supported in the record by evidence of the victim's account of the crime and the crime scene. Emphasis added. People v. Vasquez, 159 AD, 3D 517, 69 NYS, 3D 801 Step 2018. The police already had probable cause to search defendant's cell phone based on an independent source, in that the victim told the police that defendant had shown her sexually explicit photographs in the course of his sexual abuse, and this was the basis for the warrant. Emphasis added. People v. Richardson, 9 AD, 3D 783, 788, 3D Dep 2004, applying the more appropriate independent source exception to the exclusionary rule. We find suppression of the physical evidence was not required here, because it was seized pursuant to a valid search warrant which was based upon sufficient and tainted information obtained by the state police prior to and independent of the illegal detention. Emphasis in original. The prosecution also claims that Mr. Mangione cannot claim that the warrantless searches were confirmatory searches, unlawful searches that the officers carried out to assure themselves that there is cause to obtain a warrant. Response at 86. Quoting Burr, 70 NY, 2D at 362. In Burr, the Court of Appeals cautioned against the use of confirmation searches, to permit the police to search first and obtain a warrant only if their search uncovers or confirms that there is incriminating evidence, would ordinarily violate the warrant requirement. Were such a practice countenanced, the police might easily avoid having to demonstrate lawful probable cause as the law demands. They could instead achieve certain cause by conducting an unlawful confirmatory search, thus saving themselves the time and trouble of obtaining and executing a warrant if they do not find the evidence. So insulated, the police could safely engage in such conduct because, if evidence were found in the course of an illegal search, they would still be permitted to seize it in a second search under independent color of law and use it at trial. Obviously, such a practice undermines the very purpose of the warrant requirement and cannot be tolerated. Burr, 70 NY, 2D at 362, citations omitted. In arguing that the warrantless searches here were not confirmatory, the prosecution claims that because Altoona law enforcement did not think that they needed a warrant to search the backpack, their warrantless searches of the backpack cannot have been designed to assess whether they should later apply for such a warrant. Response at 86. The prosecution argues that Sergeant Houston's testimony reinforces this conclusion because he explained that the reason that APD applied for a search warrant was that it needed judicial authorization to transfer the property in question to NYPD. ID. Therefore, the prosecution argues the decision to obtain the warrant was thus not motivated by an interest in justifying APD's previous searches, but rather only to ensure a seamless transfer of the property to another police department, ID. This argument, however, ignores two key facts. First, as noted in Mr. Mangione's opening brief, pages 26-27, there were at least two supervising officers, Corporals Garrett Trent and Brian Miller, that believed the officers needed to obtain a warrant before continuing the warrantless search at the precinct. Second, contrary to the prosecution's claim, Sergeant Houston did not seek the warrant only to ensure a seamless transfer of the property to another police department. As noted above, Sergeant Houston requested the search warrant, in part, to seize the items located during the search incident, to arrest and inventory of Mangione's property, to continue the search of the items, maintain possession of, and process the property in relation to the crime of homicide, forgery, firearms not to be carried without a license, possessing instruments of a crime, X12A at 3. If Altoona law enforcement truly believed that its previous warrantless searches were proper, Sergeant Houston would have only sought the warrant to transfer the seized property to the NYPD. Tellingly, he also sought the warrant to seize the items located during the search incident, to arrest and inventory of Mangione's property, demonstrating that the earlier searches were confirmatory for conclusion for the reasons stated in Counsel's April 30, 2025, omnibus motion, at the December 2025 suppression hearings. In Mr. Mangione's opening brief and this reply, we respectfully request that this court grant the requested relief. Respectfully submitted, Karen Friedman and Idelmark Anna filed, Jacob Kaplan, counsel for Luigi Mangione CC, District Attorney's Office, via email.
Basically, this is Karen Agafilo's reply towards the prosecution's reply for them wanting to suppress Karen Agafilo's motion, wanting to suppress all the alleged evidence they found in Luigi Mangione's backpack, and also the statements Luigi Mangione made before his Miranda rights were read to him. And this is Karen Agafilo's response to the prosecution's response about that. That was a mouthful. I swear, they just keep adding the word response. A little bit of a mouthful. Basically, that's what this document is. Anyway, basically, in this document, Karen Agafilo says the prosecution say illegal search of Luigi Mangione's backpack because they were going to find the stuff anyway once they got to the police station, when in reality, yeah, it absolutely was. They also bring up in the document this does fall underneath Pennsylvania law and also New York law as well, of what they did was illegal when they searched Luigi Mangione's backpack at that McDonald's and also multiple times at that police station before they got that search warrant. And like we already know and we discussed before in the past, Luigi was way too far away for them to, lawfully search Luigi Mangione's backpack like they were claiming, but in reality, no, he was way too far from his backpack to count for that to be a lawful of arrest to search Luigi Mangione's backpack. In reality, because like we already know, he was way too far from his backpack to fall underneath that category that they are all claiming they were doing. They bring up in the document, the prosecution say the search incident to arrest they are claiming they were doing, to find a bomb and stuff, we'll go over that in a minute. Basically saying what that does not fall underneath the Pennsylvania law, and it was totally fine for them to do it, even in New York law. But in reality, they do prove in this document, yes, Luigi was way too far away from his backpack in Pennsylvania, and that does fall underneath that law in Pennsylvania for that to be illegal for them to do that, not just in New York law. They also bring up in the document of basically what the Altoona police did when they were searching Luigi Mangione's backpack without a search warrant illegally multiple times. They said it does fall underneath Pennsylvania law and they were following Pennsylvania law. And they also bring this up in the document as well, saying the Pennsylvania police were following Pennsylvania law and it would not make sense. They also bring up in the document, the prosecution argued the police force in Pennsylvania were following Pennsylvania law, not New York law. And yeah, obviously they're in Pennsylvania. Why would they follow New York law? That makes no sense. And they bring up in the document basically because this is a New York case. The crime happened in New York. This is a case happening in New York. So basically, all the evidence they allegedly found in Luigi Mangione's backpack that was illegally searched at that McDonald's needs to be thrown out because that falls underneath New York law. And that would have been thrown out. Same thing in Pennsylvania as well, because it falls underneath that category in Pennsylvania law as well, not just in New York law. They bring that up again. What are you guys all about? That's not what they were arguing in their motion. Prosecution. That's not what Karen was arguing about. Notice that in the prosecution's motions where like they pick one thing and then they argue about that when it's not the argument they were making, if that makes sense. It's like, no, that's not what Karen was arguing about in their document. Also bring up in their document basically when Officer Detler walked into that McDonald's and said he knew it was the New York shooter once Luigi Mangione pulled down his face mask. Again, an unfair bias right there into this entire case. But basically they bring up they're not going to be talking about and arguing about his statements in this document. They are going to be arguing and talking about what the prosecution wrote in their motion. Again, I think we got a little bit more context if I read their motion, but again, we don't have much with that document. I do apologize about that. If you guys do find it, please send it my way. But I do feel like in the context of this document, the prosecution were arguing with random things that don't really matter when they argue about things. It's like, this isn't what we're talking about, guys. Why are you arguing about this? When that's not what we're arguing. Prosecution argue it doesn't fall underneath that other category of basically when they found Luigi Mangione's notebook and when they read it and stuff like that, because they found it in a different pocket in Luigi Mangione's backpack at that McDonald's. Again, this is the first time we've heard about that notebook at that McDonald's. I could be wrong, I don't remember. I've read a lot of these documents, but basically they bring that up in the document as well. Again, it doesn't really make sense, if that makes sense. Like, I've read things from the prosecutions before, and it's like, this does not make sense. Make it make sense. Like, I need to stop saying I went to I'm genuinely serious. It doesn't make sense. Like, why? What? Like, from the prosecutor side of things, I think, anyway. And they also bring up in the document, Pennsylvania police knew Luigi Mangione would be trialed in New York because this is a New York case, and including the amount of times Officer Inelli contacted people in New York, and they definitely knew this is going to be a New York case because of that reason. Like we already know, they did so many things for New York before they were even asked. It's so nice of them, isn't it? They were never asked to do any of those things, but they did it for New York anyway. How nice. Hope you can hear the sarcasm in my voice in that last little bit. You know, it's like a little bit of a common sense. Of course you guys are doing, of course this is going to be a New York case. The shooting of Brian Thompson happened in New York. Of course it's going to be happening in New York. You guys contacted New York multiple times. It's bluntly obvious this was going to be a New York case before a Pennsylvania case. Basically, the prosecution argues saying how would have the officers in Pennsylvania would have known they were breaking New York law because they are in Pennsylvania. No shit. Obviously they wouldn't have known that because they're in Pennsylvania. Think about that a little bit harder in your stupid argument, prosecutors. And then Karen Acafillo brings up in her argument of that stupid thing the prosecution said. Basically, they bring up in the document the Pennsylvania officers knew they were looking for the CEO shooter that happened in New York, of course, and they were in contact with New York all the times out through the day. In the document, they also bring up the timeline of the amount of times they were contacting people in New York because this is a New York case. Of course New York would have gotten involved. It's a bit dumbfounded of them to say how would have Pennsylvania officers would have not known New York would not get involved. It's such a dumb argument, like, from the prosecutors. It's like, how would have they known? They're not in New York. It's such a dumb argument. And I know I have not read the prosecution side of things, but I feel like that's 100% how it came off. That's from that little sentence we got in Karen Acafillo's response to the prosecution's responses. It's so dumb. This, I thought it was kind of funny, again adding to the rose-tinted glasses of what the prosecution say of Luigi Mangione's arrest. Basically, the prosecution argue and say, yes, the Pennsylvania police force were working in good faith and following the law by the book, and basically, no. And basically argue, no, the Pennsylvania police officers did not break that law whatsoever. They were working in good faith. In reality, no, they weren't. It's been disproved multiple times by Karen Ockefeller's motions we've read multiple times over the last couple of months. I've shown you guys. Basically, it has been disproven. Luigi Mangione was way too far away from his backpack to actually, for them to claim they were doing was legal. In reality, it was not. Because again, Luigi Mangione was way too far away from his backpack. There were multiple officers between Luigi Mangione and his backpack for this to be valid. Basically, this entire document is just basically Karen Ockefeller disproving all the arguments the prosecution made of their document. This I found absolutely hilarious. So basically, the prosecution argues saying, yes, this does fall underneath that category. Luigi was arm's length away from his backpack. It's bluntly obvious he wasn't. If you look at the screenshots from when Luigi Mangione was arrested, you can clearly see he wasn't. It's bluntly obvious. And if you're blind and you can't see that, well, you guys can count. He was about 13 feet away from his backpack. Hi, it's voiceover me. So I do want to add this little sarcastic note here. No one's arms are 13 feet long. They also bring up in the document, because this is a New York case, and everything they allegedly found in Luigi Mangione's backpack, and also the statements Luigi Mangione made to police before his Miranda rights, this whole thing would have been dismissed. But again, the prosecution making everything difficult, and it's like pulling teeth. They also bring up in the document, the prosecution argue and say they were doing this and it was okay because they were searching for Luigi Mangione's backpack, making sure there wasn't any bombs in it or anything like that. But like we already know, and also came out in the December suppression hearings as well, basically that bomb excuse was a fucking lie because, you know, Officer Waza realized, oh shit, I fucked up, I need a search warrant, let's make up a good excuse. Bomb, good idea. And like we already know, that came out in the December suppression hearing. It's also brought up in the same document as well of how much Officer Fox and also Officer Waza were not taking this bomb excuse very serious whatsoever. They were very much joking around. Now, if there was a bomb and they were actually looking for a bomb in Luigi Mangione's backpack, they would have brought it outside and evacuated the McDonald's. They brought that up as well in the document of them literally not taking it seriously. They would evacuate it. On top of that, they also let people walk past so they could use the toilet, or American terms bathroom in their case, when they were going through Luigi Mangione's backpack. And on top of that, they were going through different little containers in Luigi Mangione's backpack that would definitely 100% would not have a bomb in it, like little containers, envelopes, etc. at that McDonald's, a bomb in it whatsoever. They also bring up in the document they stopped searching through Luigi Mangione's backpack after they found that gun magazine in Luigi Mangione's backpack. Officer Waza and Officer Fox both stopped searching through Luigi Mangione's backpack, and all claims for them searching for a bomb just vanished after them finding that gun magazine in Luigi Mangione's backpack. Again, it makes no sense. If they were searching for a bomb, I think they would be more concerned about that bomb in that backpack compared to, you know, forgetting about it once they see that, you know, that gun magazine. I have this written in my notes. I think the prosecution's response to Karen Ockefeller's response to wanting to suppress everything in Luigi Mangione's backpack that was allegedly found, and also his statements, were incredibly whiny from the prosecution just from reading Karen Ockefeller's response. They also bring up in the document the prosecution argues saying they were also going through Luigi Mangione's backpack at the McDonald's, saying they were looking for a gun in Luigi Mangione's backpack at that McDonald's. Now, I do want to say this here. A gun was never brought up at that McDonald's they were searching for whatsoever until now, until the prosecution mention it. Now, is this them using the excuse to cover Officer Waza and Officer Fox's backs because of what they fucking did was incredibly suspicious of them pulling over to the side of the road without many CCTV camera footages, carrying 2 separate bags in 2 different police cars? Like, seriously, how can you make that sound any less suspicious? So I think that's what the prosecution are doing, are trying to cover Officer Waza and Officer Fox's backs of what the fuck they did. They also bring up as well, none of that was ever brought up in CCTV camera footage at the McDonald's. That's what they were searching for at that McDonald's. Compared to the bomb, that's what they were searching for, not at the McDonald's. If they also bring this up in the document, basically bringing up, if they were worried about a bomb, why did Officer Fox spend more than a minute basically trying to open a little piece of cardboard that he knew there was no bomb in it, that basically had a little piece of computer technology in it? Again, like we already know in the December suppression hearings, the officers say it was a computer chip, and then they would say it's like a different piece of a computer equipment altogether. Again, I don't remember what it's called, it's been a while since I read those, but basically a little piece of something for your computer that was found in that little, allegedly found in that little piece of cardboard. I do think that ever came out in the alleged evidence they released to the internet on that day. Basically, they bring up, why would someone spend so long trying to open a little piece of cardboard when they were literally searching for a bomb in someone's backpack? They would be more concerned about, the thing in the backpack that had a bomb. Things with bombs, they kind of have a time strain thing on them. It's what they do. It's what bombs do. It's their thing. So it makes no sense for Officer Fox to spend so much time on that when they were actually looking for a bomb they were claiming. Again, doesn't make any sense. I just have this quote from Karen in my notes of them going through Luigi Mangione's backpack was a post hoc excuse. I love these little digs Karen does in her documents. They don't happen often, but they're great when they do. They're the best. I love them. They're so professional, but so funny at the same time, of these digs. And basically the prosecution are trying to basically cover up Officer Waza and Officer Fox's actions of what they did. Basically was, incredibly suspicious, and basically cover Officer Waza's actions of how magically that 3D printed gun appeared in Luigi Mangione's backpack. Like we already know, they did a much thorough search of Luigi Mangione's backpack at that McDonald's. Then they were leading on, like we already know, Officer Fox, he was going through the pockets of that backpack at the McDonald's, and then Officer Waza was looking for the main part of the bag of Luigi Mangione's backpack at the McDonald's. And like we already know, Officer Waza, she said she found the 3D printed gun in one of the pockets that was in Luigi Mangione's backpack. Like we already know, Officer Fox was going through the pockets. He would have seen that when he was at the McDonald's, compared to, Officer Waza finding it at the police station where it magically appeared. Make it make sense, prosecutors. You're not doing a very good job. Also, I thought this was incredibly funny when I was reading the document. I literally have, haha, this was funny. Anyway, so, bring up in the document, basically the prosecution say what Officer Waza did when she searched for Luigi Mangione's backpack at the police station in that hallway without any CCTV cameras in it, on a small chair in a hallway without any CCTV cameras in it, and basically when she was doing that search was warranted. It was not. We can all tell. We all know. And basically they also bring up, we can see it in the CCTV camera footage, because again, like we all know, she was claiming she was doing a inventory search of Luigi Mangione's backpack when she wasn't. They also bring up in the document, it makes no sense for them to do a inventory search of Luigi's backpack on a small chair in a hallway without any CCTV cameras in it. But the only camera was turned on was Officer Waza's body cam footage that was turned on. And they also bring up in the document as well, Officer Waza was looking for a very specific pocket in Luigi Mangione's backpack instead of randomly going through each single pocket randomly at times. Instead of, doing a inventory search where they need a table so they can put everything out and, write things down. That never happened whatsoever. Though that was hilarious, the prosecution say, no, this was warranted. No, it wasn't. They also bring up basically when the prosecution argues saying what Officer Waza was a inventory search when it doesn't make sense, and they just basically break it down and explain why it doesn't make sense for her to do a inventory search on a chair in a small hallway when you need lots of room and paper to write whatever was found in that backpack. Reality, it doesn't make sense, and they basically disprove that in the document of what Officer Waza did was not a inventory search whatsoever. And also they bring up as well, it doesn't make sense for Officer Waza to go through Luigi Mangione's backpack on the side of the road before she got to that police station. It doesn't really make sense for them to do that. They also bring up in the document the prosecution don't really know why Officer Waza would go through a backpack on the side of the road in secret before she got to that police station, and they basically bring up 100% the reason why Officer Waza would do that is because she wanted to be included and be the one to find that 3D printed gun in Luigi Mangione's backpack, and be part of this massive investigation that has infatuated the entire world at this point in time, that has lasted about 5 days. She wanted to be the one to find that 3D printed gun and be included and be the one who was the one who found that 3D printed gun, and that's why she also made sure her audio was turned on her body cam so she can be credited. 100% proven right. Anyway, I said it a lot more sarcastically and then how professionally how they said it, but basically that's what it was, and that's why they explained the reason why she would do that. I do find it funny, the prosecution said, yeah, we don't know why they did that, that's weird. Yeah, it is weird. Also bring up basically every time those officers searched Luigi Mangione's backpack at that police station when they were claiming they were doing a inventory search, like we already know they weren't. They did it multiple times without that search warrant, including when Officer Waza did it on that chair, when they brought it to Officer Featherstone's office and did going through Luigi Mangione's backpack there as well. Again, all of them were claiming they were doing a inventory search when that was not the case whatsoever. Also bring up in the document, Judge Garnett is only using Pennsylvania law for going over and reading basically a inventory search compared to using New York law for the inventory search, because the Altoona, Pennsylvania law for them to do that is outdated compared to New York law, if that makes sense. Need to stop saying that. They also bring up as well when they were doing that so-called inventory search, and it does fall underneath that law so-called in New York, and it was okay for them to do that. In reality, they go over and explain, what Officer Featherstone did, and also I forgot the other officer's name. Also bring up basically what Officer Waza and the two other officers basically did when they read through Luigi Mangione's writings and say it was him. It does not fall underneath that category for them to do that when they were doing a inventory search. They explain if they were doing a inventory search and it was legal, they would have the right to take the journal outside of the backpack and then write it down, not go through the contents of the journal and actually read it. They also bring up as well in the document, the prosecution argue saying what Officer Featherstone and Officer Hanley did was totally fine, it was okay, and in reality, no, it wasn't. They also bring up the statements from the December suppression hearing of one of the officers said he literally just read Luigi Mangione's journal just out of curiosity, and instead of, not reading it, and only took pictures of certain pages instead of, taking pictures of all the pages, because, context matters. Also bring up in the document they should suppress Luigi Mangione's alleged writing, because literally they've read his writing when they did not have permission whatsoever, and stuff like this has happened in the past, and it has been suppressed. They also bring up as well when they officially got that search warrant to search through Luigi Mangione's backpack was actually 6 p.m. on that very day when Luigi Mangione was arrested, but like we already know, they searched through his backpack multiple times without that search warrant. They basically say everything they allegedly found in Luigi Mangione's backpack is fruit from the poisonous tree, because everything they found is tainted before they got that search warrant. We haven't heard that saying in a hot minute, haven't we? They also bring up in the document basically everything they allegedly found in Luigi Mangione's backpack before they got that search warrant, they used so they can get that search warrant, including the things they have read in Luigi Mangione's alleged writing in his notebook. Like we already know, they were only looking for incriminating evidence in his alleged writing, and basically they used that so they could get that search warrant so they can go through Luigi Mangione's backpack legally, but basically everything they used was illegally found already. It also comes out in the document, basically the officer, I can't remember which one, I'm sorry. It also comes out in the document the officer who filled out the official paperwork for getting that search warrant. Basically, he only found out Detective Diaz was using the alleged evidence they found on his backpack so they can go move forward in their investigation. It also comes out in this document as well, the officer that filed the official paperwork to get that search warrant. I'm sorry, I forgot their names, it's one of them. There's a lot of them and it's hard to keep track. Basically, only got the information of what allegedly was inscribed of the bullets by Detective Leonardi, and Leonardi using those alleged evidence they found on Luigi Mangione, and then on top of that, he only found out the alleged shooter left on a bus. He only knew about that information after he filled out the paperwork. Basically, this entire document is just Karen Occhifilo disproving every single argument the prosecution are making in their response. That was the end of my little notes and breakdown of basically Karen's response to the prosecution's response to when Karen Occhifilo wanted to suppress everything that was allegedly found in Luigi Mangione's backpack, and then also Luigi Mangione's statements towards the police before his Miranda rights were read to him. Again, I don't know where I can find the actual official document from the prosecution. Reading that again, I showed you like 3 pages. If you guys know where to find it, please send it to me and I'll read it, I think. But I think I got enough context reading Karen's response from this. Anyway, the 18th of March 2026. This is a motion from Karen Occhifilo. I'll pop it up on screen for you guys.
March 18th. 2026 via ECF, the Honorable Margaret M. Garnett, U.S. District Judge, Southern District of New York, 40 Foley Square, New York, New York 10007 Re, United States v. Mangione, 25 CR 176, MMG, Dear Judge Garnett, on February 3, 2026, this court entered an order setting the schedule for Mr. Mangione's federal case with in-person voir dire starting on September 8, 2026, for an October 13, 2026, trial. As part of this schedule, the jury questionnaire process would start on April 13, 2026, with the parties exchanging proposed questionnaires that would be distributed to potential jurors the week of June 29, 2026. As this court is aware, on February 6, 2026, Justice Gregory Carros of the New York Supreme Court set Mr. Mangione's state trial for June 8, 2026. When setting this trial date, Justice Carros noted that, if the federal trial did not take place in fall 2026, he would move the state trial date to September 8, 2026. As a result of these competing schedules, Mr. Mangione is now in the position of needing to prepare for 2 complicated and serious trials at the same time. This scenario violates several of Mr. Mangione's constitutional rights. First, Mr. Mangione has a right to meaningfully participate in all stages of his trial, including the jury selection process. As the Supreme Court has noted, jury selection is the primary means by which a court may enforce a defendant's right to be tried by a jury free from ethnic, racial, or political prejudice, or predisposition about the defendant's culpability. Gomez v. United States, 490 U.S. 858, 873, 1989, internal citations omitted. Accordingly, jury selection is a critical stage of the criminal proceeding, ID. See also ID. Even though it is true that a criminal trial does not commence for purposes of the Double Jeopardy Clause until the jury is empaneled and sworn, other constitutional rights attach before that point, internal citation omitted. because Justice Carros scheduled the state trial for June 8, 2026, Mr. Mangione is now in the impossible position of having to review 800 jury questionnaires during the week of June 29, 2026, while on trial for second-degree murder in state court. As a practical matter, this would not be possible. Every trial day, Mr. Mangione would be taken to court for trial and returned to MDC later that night. By the time Mr. Mangione returned to the MDC, it would be too late for a legal visit for counsel and Mr. Mangione to review the completed juror questionnaires. On non-trial days, counsel and Mr. Mangione would be preparing for trial and would not be able to spend the required hours to review 800 juror questionnaires. Moreover, because each completed questionnaire would include the potential jurors identifying information, Mr. Mangione would only be able to review the questionnaire in the presence of counsel and would not be allowed to keep the questionnaires at the MDC. Given all these practical restraints, Mr. Mangione would not be able to meaningfully review the questionnaires and would not be able to assist counsel in determining whether to challenge potential jurors for cause, as he is entitled to. Second, both the federal and New York state constitutions guarantee a defendant's right to the effective assistance of counsel. Though fierce advocates for their clients, defense counsel cannot be in two places at once. Realistically, defense counsel cannot be defending Mr. Mangione in state court on second-degree murder charges that carry a maximum sentence of 25 years to life while, at the same time, also reviewing 800 questionnaires for a federal case that carries a maximum life sentence. Moreover, counsel will not be able to adequately prepare for the federal trial because they will be on trial in state court. Third, Mr. Mangione is entitled to a trial by a fair and impartial jury. Unfortunately, the media reporting surrounding this case has been unrelenting and unparalleled, even when compared to other high-profile New York City cases. As a result, forcing Mr. Mangione to start the state trial on June 8, 2026, 3 weeks before potential federal jurors start filling out juror questionnaires a few blocks away in Mr. Mangione's federal case, guarantees that the fairness and impartiality of Mr. Mangione's federal jurors will be negatively impacted by weeks of media reporting. This is particularly true in this case because the evidence in both trials will be nearly identical given that both prosecutions are based on the same exact set of facts and both prosecutions will rely heavily on police work done by the NYPD. As a result, Mr. Mangione's potential federal jurors will be constantly bombarded with news reports and social media posts relating to the allegations and evidence against Mr. Mangione as they fill out juror questionnaires and in the subsequent weeks before they are empaneled in the federal case. Given these constitutional concerns, counsel is left with no other option than to respectfully request that this court adjourn in person voir dire and trial in the federal matter to January 2027. So that Justice Carros can adjourn the state trial to September 8, 2026. Thus, the current federal trial schedule would move back roughly 4 months. 1. This proposed schedule would allow sufficient time between the state and federal trials to address the constitutional concerns noted above, while also providing counsel additional time to gather all necessary information and adequately prepare for the state trial, that has different elements and different differences than the federal case. We further note that this court made the following statement during January 30, 2026, appearance relating to the potential conflict of the trial schedules. I know I am aware of the letter that Mr. Statement filed with Justice Carros. You know, as I said from the outset, unless and until someone wants to make an application to me, my view is that that case is none of my concern, and I certainly can't. You know, we have to proceed as if this is the only case, unless of course one should the court grant this request. The parties would propose new dates for the jury questionnaire process that does not interfere with Mr. Mangione's state trial. The government or defense, or if the Manhattan District Attorney wanted to send me a letter or something, we'll deal with it as it comes. The 30th of January 2026 TR at 7'8". See also the 25th of April 2025 TR at 12. I think I agree with Mr. Gentile that we will, barring some request otherwise, my intention is that we will set a schedule for this case as if it's the only case, and should an issue arise involving a conflict between the scheduling that either party wants to bring to my attention, you can certainly do that, but I think in terms of our management of this case, We ought to proceed as if it's the only case until circumstances suggest otherwise. Because of the issues raised above, we are now coming to the court and respectfully requesting an adjournment of the trial schedule. We have spoken with the government about this request. The government notes that Mr. Mangione's state and federal matters are independent cases and therefore objects to adjourning the federal in-person voir dire and trial dates because of this state matter. The government has indicated that it will respond under separate cover. Respectfully submitted. Karen Friedman Anafilo Mark Anafilo Jacob Kaplan Counsel for Luigi Mangione.
The first part of the document is just basically them discussing and how long it's going to take for basically the trial date selected by Judge Garnett. They also bring up in the document of when Judge Carros made his decision of when he decided Luigi Mangione's trial that would start on June 8th, 2026, and he said if there are going to be delays they would move it back to September 8th, 2026. Again, not moving it by much. So bring up in the document Luigi Mangione has to prepare for two very important trials now compared to one, and again one's happening right in the middle compared to the other one that's happening later on. Again, it's bluntly unfair. And they bring up in the document as well violating Luigi Mangione's rights again. Are we surprised? They love violating his rights and not respecting it because of the massive HEPA violation that's obviously going on. This I found incredibly interesting. So they did bring up jury selection and basically jury and double jeopardy. Basically the jury selection needs to happen first and then double jeopardy can be enacted, and basically a number of other things also have been going on violating Luigi Mangione's rights as well that they also need to consider as well moving forward. Basically they bring up in the document, they basically put Luigi Mangione in a very impossible position. Basically, if Luigi Mangione trial happens on June 8th, 2026, and then Luigi Mangione would have to be sent right back to NDC. That's where he's being held, and basically on June 29th, Luigi Mangione would have to read and review all 800 questions for the jury selection, and they basically put Luigi Mangione in an impossible position because, you know, right after trial he would be sent back to NDC and he would not be able to, you know, take any of these legal documents or have any time to talk to his legal team for the questionnaire for the jury selection, and he would not be allowed to take any of that stuff with him at NDC, again putting Luigi Mangione in a very impossible position. Basically, you know, not being prepared whatsoever, you know, because literally he's at MDC, he's not allowed anything there. Also, it's bluntly obvious like what they're doing, like making this entire case incredibly impossible for Luigi Mangione and his legal team to have a fair trial. It's insane. Like, honestly, it's so infuriating where they have to write the most simplest things down in paper where it's bluntly obvious, but we've seen this many times before where they actually have to ask, can Luigi Mangione wear court approval clothing, when in the other case they totally would do it right off the bat and they wouldn't have to write anything down, and also them not being handcuffed and shackled. But we've seen it so many times, they have to write things down or nothing will happen. Again, it's very annoying and very infuriating. They have to write the most simplest things down so Luigi Mangione can at least have his rights not violated. But like we already know, they do it so many times. They also bring up in the document because, you know, Luigi Mangione can't read all the questionnaires and be there in person to basically confront some juries, people that are for jury selection. That is his right to do so because, you know, he is busy in trial for an entirely different thing, and again making it entirely impossible for Luigi Mangione to basically do anything and have a fair trial. They also bring up as well, Luigi Mangione's legal team cannot be in two places at once, you know, being in one trial and then being part of the jury selection questionnaire. You know, they're meant to be there. No one can be in two places at once. We all wish we could, but we can't. They also bring up in the document because of the high profile of this case and the media attention surrounding Luigi Mangione's case, and basically 3 weeks later Luigi Mangione's jury selection would have happen in Judge Garnett's trial for Luigi Mangione, it would bluntly make it unfair for Luigi because, you know, the media loves talking about Luigi Mangione. You are obsessed! And don't talk about anything that is accurate or factual in this case, and thus it makes them look good. The jury selection, they would be influenced by what they saw on the news or media or on social media surrounding this case when they are being part of the jury selection surrounding this case, because like we already know, this is a very high profile case. Everyone's interested in this case, everyone's infatuated with this case because of Luigi Mangione's looks or otherwise, etc. Again, they would be very much influenced by that when they are doing the jury selection questionnaire, because you know how high profile this case is. Like we already know, the news doesn't really like talking about factual information in this case and telling us what's going on. Also in life in general as well, by the way. I would taint Luigi Mangione's right for a fair trial and have fair jury selection in this case. Document basically, can they move Judge Garnett's trial date to 2027 so they can be prepared for Judge Carros' court date, so they can move that to September 8th, 2026, giving them roughly about 4 months between the two trials, giving them enough time to be prepared for both trials, and also not violating Luigi Mangione's rights. Brought up in the document, Judge Garnett has received a letter of where on January 30th, 2026 of Judge Carros' decision of when he wants to make his court trial date for Luigi Mangione, but she said she hasn't gotten any official filing yet about that, so she's just going to move forward as her trial is the only trial going forward. So like, she knows Carros' antics, but she's not doing anything about it much. And they also bring up basically, if this does go forward for Judge Garnett's trial date for Luigi Mangione to be in 2027, they'll select a new date for jury selection if this does go forward. Also brought up in the document, if the prosecutors or even the United States government or even Luigi Mangione's legal team want to submit a letter, and they will organize something. And now this is basically the letter they are submitting to Judge Garnett so they can organize and fix all this, because literally what is going on is double jeopardy 100%. So this is Luigi Mangione's legal team submitting a letter so something can happen. They did talk to the United States government about it, and basically the United States government's response was, we're going to treat this as two separate cases, and it doesn't really matter if two trials are happening at the exact same time. You can be as mad as I am about that, like Jesus fucking Christ, why? And it's bluntly obvious, basically the prosecution in this case are bluntly trying to make it vertically impossible for Luigi Mangione to have a fair trial every step of the way, and it's infuriating and it's obvious. The 19th of March 2026, basically this is a document from the prosecutors basically replying to Karen Ocafillo's letter to basically suppressing the alleged evidence in Luigi Mangione's backpack. Please take this document with a little bit of skepticism. I did get this from Reddit, so I'll pop it up on screen for you guys.
March 19, 2026. The Honorable Gregory Carro, Justice of the Supreme Court of the State of New York, Part 32, Room 1300 100 Center Street, New York, New York 10013 Re. People v. Luigi Mangione. Indictment No. IND 75-657, 24. Dear Judge Carro, we write to respond to 4 contentions raised for the first time in defendant's post-hearing reply in the above captioned matter. Defendant argues that the APD officer's handling of his closed notebook at the McDonald's constituted a search. Reply 1N 2. But the notebook was itself a closed container, such that it needed to be opened to be searched. See People v. Lewis, 195 AD, 3D 427, 427. First step 2021, an envelope recovered from the defendant's person was a closed container, which officers searched by opening. The notebook was thus not searched until it was opened by Wasser at the station house, and once she lawfully opened it, defendant no longer had any expectation of privacy in it, such that any subsequent inspections of the notebook did not intrude upon defendant's privacy interests. See U.S. v. Johns, 469 U.S. 478, 486, 1985, After customs officers lawfully conducted a warrantless search, D officers could subsequently conduct such a search. People v. Batista, 209 AD, 2D 326, 326, First Step 1994, citing Johns for the proposition that a second warrantless search of a car did not constitute an invasion of the defendant's right to privacy. In any event, as detailed in point 2D of our main submission, the APD officers' subsequent inspections of the notebook were properly carried out in accordance with APD inventory procedure and with the relevant law. See People v. Good, 176 AD, 3D 629, 629-30. First Step 2019, approving of the retrieval of credit cards from an arrestee's wallet given the long-recognized reasonableness of station house inspections of arrestee's personal effects. See also People v. Peril, 34 NY, 2D 462, 468-69, 1974, allowing officers to scrutinize an arrestee's address book and papers at the station house pursuant to their authority to search and inventory the arrestee's possessions. Defendant also argues that, when APD officers searched him incident to arrest at the McDonald's, they should have followed New York search and seizure law because they were in near constant contact with NYPD investigators. Reply 2. But the evidence at the hearing established that it was not until well after APD officers, who themselves were unfamiliar with New York search and seizure law, had left the McDonald's that NYPD investigators contacted them. In any event, as detailed in point IC of our main submission, the record establishes that at least two exigencies, concerns about a bomb and concerns about a firearm, rendered the McDonald's search lawful under New York search and seizure law. Defendant goes on to urge the court not to be persuaded by the federal district court's finding that APD officers conducted a proper inventory search of the contents of his backpack. Reply 5. He stresses that the federal district court applied federal law rather than New York law in evaluating APD's inventory search. Reply 5. But he also urges this court to follow federal decisions like U.S. v. Santos, 961 F. Sup. 71, SDNY 1997, to overturn the inventory search. Defendant cannot have it both ways. The fact of the matter is that the inventory search of his backpack comported with both New York law and federal law, which do not appear to differ significantly from one another in this area. Compare People v. Douglas, 40 NY, 3D 385, 388, 2023, with U.S. v. Williams, 930 F, 3D 44, 54, 2D C 2019. Finally, defendant claims that the independent source doctrine does not apply here because APD's application for a search warrant for defendant's backpack included information that APD had discovered during the assertedly unlawful searches of that backpack. We maintain that those prior searches were lawful for the reasons outlined in points I and E of our main submission, but even if those searches were somehow unlawful, other information, including information that NYPD had disseminated via the media, independently provided probable cause supporting the search warrant for defendant's backpack. Defendant stresses that it was not until after the assertedly unlawful searches of the backpack that APD spoke to NYPD Detective Oscar Diaz and received confirmation of the information disseminated by NYPD via the media. Reply 7-8. It is not clear, however, why that matters. NYPD investigators had already gathered all of that information before the assertedly unlawful searches, and APD began trying to contact NYPD before any of the assertedly unlawful searches, thus demonstrating that APD's procurement of the warrant was not causally related to the contrary to defendant's claim. Reply 3. The record thoroughly establishes APD officers' concerns about a firearm. See point IC 2 of our main submission. Assertedly, illegal police conduct. People v. Arnor, 58 NY, 2D 27, 32, 1982. The independent source doctrine therefore applies, providing an additional basis for denying suppression of the contents of defendant's backpack. Sincerely, Joel J. C. Eidman, Joel J. Seidelman, Senior Trial Counsel, Assistant District Attorney, 212-335-4186 CC, Karen Friedman, Anafilo.
I have in my notes, I can tell I was incredibly tired. I was just thinking out loud writing my notes here. But basically, my first half of my notes of this document was going, no, I'm not gonna read this, nah. And then I started reading it, and then it's just like, no, I'm gonna talk about this now. And I just wrote in my notes, I wanna roll my eyes so hard out of my head reading the prosecution's bullshit excuses. So anyway, I'm gonna read you my passive-aggressive notes of reading the prosecution's document. I would take it more seriously if they've written it more seriously. That's not a joke, okay? Literally, the first line in the prosecution's document is literally them saying, they literally said, like, no, the journal that they got out of Luigi Mangione's backpack with the alleged writing, it was a closed container. What the fuck? It's a book. It's not a container. It's so dumb. No, it's not. It's a book, not a container, guys. What the hell? And the prosecution also say basically the reason why they opened little envelopes that they allegedly found in Luigi Mangione's backpack, they are claiming that was also a closed container. That's not the argument Karen Acafillo was making. The argument Karen Acafillo was making was the Altoona police force read Luigi Mangione's alleged writing and also the alleged notes without getting a search warrant, but claiming they were doing a inventory search, but instead they just read the alleged writing and the alleged notes, not saying they opened it and saying it was a container. That's not the argument Karen Acafillo was making. She wasn't saying it was a container. No, they're not. A journal is not a container. A little envelope is not a container. Those are two separate things to a container. I also argue with the prosecution's documents when I read them. Not here, you can just hear my frustrations. I'm genuinely serious, that's not the argument Karen was making, guys. It might sound very sarcastic and not taking it seriously when I'm reading the documents from the prosecution, but if they had things written more seriously and not pulling things out of thin air, I would take it a lot more seriously and not less sarcastically, but I'm genuinely serious, they're making up anything and anything to cover up their own asses, even the Altoona police officers' own asses, and literally just pulling things out of thin air. It's like, what the fuck? No, not the argument people are making. Why? It's honestly infuriating. It's like arguing with a child sometimes reading the prosecution's documents. It's like, no, your logic makes no sense, no. And then you explain the logical answer, and then they argue with something totally different, no. It comes out in the document as well by the prosecution basically saying, yes, they were following New York law. Why would they be following New York law in their own state? In Pennsylvania. In Altoona. That makes no sense for them to actually follow New York law in their own state. But then the prosecution say, yes, they were following New York law. What? It makes no sense. It also comes out as well, the reason why the Altoona police force were going through Luigi Mangione's backpack at that McDonald's without a search warrant is because they were claiming they were searching for a bomb and also a gun. By the way, I do want to add again, the gun, this is the first time they've ever mentioned the gun they were looking for at that McDonald's compared to at the police station, where it was mentioned multiple times in many different motions. It was at the police station. That's what they were searching for, not at that McDonald's. And like we already know and seen already, the police officers were not taking this entire thing seriously when they were joking around and messing about the bomb, instead of, taking it seriously and, treating it as a real bomb threat, if that makes sense, compared to, them messing around and joking. It's literally in body cam footage of them joking around. This came out in body cam footage where Officer Fox said, hey, you can blow Fox up, but you can't blow Blue up. By the way, Blue is his police dog, by the way. So yeah, it's very much not them taking it seriously. It literally comes out in body cam footage of them not taking it seriously and messing around about the bomb they were so-called searching for that does not exist. The 21st of March 2026. This is a letter from the United States government saying, hey, can we keep the trial date exactly how it is instead of moving it forward? So I'll pop it up on screen for you guys.
March 21st, 2026 via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, 10007 Re. United States vs. Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Garnett, the government respectfully submits this letter in response to the defendant's March 18, 2026 motion to continue the current trial schedule, DKT 120, for the reasons that follow. Although the government does not object to reasonable modifications to the juror questionnaire schedule to address the defendant's logistical and scheduling concerns, it opposes the request to adjourn in-person voir dire and trial until January 2027. The concerns identified by the defense can be fully addressed through targeted modifications to the questionnaire process, rather than a wholesale continuance of the trial date in this case. The changed posture of this case further supports that approach. The extended lead time previously adopted by the court was designed to meet the unique demands of capital litigation, considerations that no longer apply. Against this backdrop, modest adjustments to the timing and sequencing of questionnaire distribution and review would afford defense counsel and the defendant a meaningful opportunity to participate in juror screening, while preserving the voir dire and trial dates already set by the court. Accordingly, if the court elects to shorten or otherwise adjust the questionnaire schedule to address counsel's practical concerns while maintaining the current trial dates, the government would not oppose such an adjustment. The court has previously indicated that, absent a specific application, it would set a schedule for this case as if it were the only matter pending. See April 25, 2025 TR at 12, DKT 27. Nothing in the defense letter alters that framework, and the government respectfully submits that the existing September 8, 2026 voir dire date and October 13, 2026 trial date, set after careful consideration by the court, should remain in place. The government further submits that the public's interest is both substantial and compelling, and is best served by proceeding to trial without delay. The defense request appears to be informed in substantial part by developments in the defendant's state court case. Nothing, however, about the current state court schedule demands the substantial adjournment requested by the defense. Continuing to maintain to the fullest extent practicable this court's existing schedule will avoid uncertainty and serve the public's strong interest in the timely resolution of this prosecution and the government's ability to proceed efficiently to trial. The government stands ready to work with the court and defense counsel to implement reasonable and achievable adjustments to the juror questionnaire timetable in light of the defendant's concerns. The government therefore respectfully requests that the court deny the defendant's motion to continue the federal trial, except to the extent the court elects to make limited modifications to the questionnaire schedule consistent with this submission. Should the court wish to hear further from the parties, the government stands ready to appear at the court's convenience. Respectfully submitted, Sean S. Buckley, Attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S/Dominic A. Gentile, June Zhang, Alexandra S. Messiter, Thomas John Wright, Assistant United States Attorneys, 212-637-2200.
Basically, in this document, the prosecution and the United States government object to moving the trial date to 2027. They'll just move things around. It's fine. They don't need to, move it until 2027. Double jeopardy is definitely not going on. The 23rd of March 2026 was an order scheduling a court date for Luigi Mangione on the 1st of April 2026. I'll pop it up on screen for you guys.
United States District Court, Southern District of New York, UNLTED, States of America, v. Luigi Nicholas Mangione, filed the 23rd of March 2026, page 1 of 1 USD/CSNY document, electronically filed doc, date filed, the 23rd of March 2026, 25 CR 00176, MMG, order defendant, S. Margaret M. Garnett, United States District Judge. A conference on the pending motion to continue trial is scheduled for Wednesday, April 1, 2026, at 11 a.m. in courtroom 110 of the Thurgood Marshall U.S. Courthouse at 40 Foley Square. So ordered. Dated, March 23, 2026, New York. New York Margaret Garnett, United States District Judge.
Honestly, I brought this up in my last video talking about this. I was honestly really surprised hearing about this, like literally a couple of weeks beforehand. We got the scheduling for the official trial date for Luigi Mangione scheduled by Judge Carros, and now this has happened for a scheduling for Luigi Mangione to appear in court again, so they can literally organize this double jeopardy that's obviously going on with Judge Garnett. Luigi Mangione will appear in court on April 1st, 2025 at 11 a.m. US time. The 1st of April 2026. On this day, Luigi Mangione appeared in court again. On this day, we did not get any photos of Luigi Mangione, but we did get one court sketch. Surprisingly, we normally get one or two, but we just got one this time. And the news that came out on this day, before we got the live tweets or anything like that, was Luigi Mangione and Karen Arcafillo seemed very calm and collected on this day, like they were kind of expecting what was going to come out from this court hearing, and I think it's what they needed to be, honestly, in this, so they can literally organize the dumpster fire that's happening in Luigi Mangione's the trial dates in Luigi Mangione's case. Actually, what came out on this day, they will not move Luigi Mangione's court date set by Judge Garnett to 2027, but they will move back Judge Carros' trial date for Luigi Mangione to September 8th, 2026. In Luigi Mangione's, instead of, making it fair, again, they just moved it back by a couple of months, not really doing much. It's honestly infuriating. I was so fucking mad when I heard this news. I was infuriated. Basically, that's what came out on this day. But honestly, I think we just have to trust Luigi Mangione's legal team and Karen. I think they were very much kind of expecting something like this to happen, and that's why they were very calm and collected on this day. All we have to do is just trust them. Now, I do want to say this here. Again, I'll bring this up later on in the video, but when we get to it, we will get a official transcript on this day. It has been filed a couple of days ago for them to have the transcript of this day be released to the public. Again, that only came out a couple of days ago. We'll go over it in more detail in a couple of minutes, but basically what we have at the moment is the live tweets from the Luigi Times. Massive thank you to you on Instagram. So I'm going to show you guys the screenshots of this day of basically Luigi Mangione's hearing, so you guys can give a vague idea of what happened in the courtroom until we get the official transcripts. Again, I'll make that its own dedicated video, but this is what we have for now, so I'll pop it up on screen for you guys.
From today's hearing, the legal team has arrived. No sign of LM or the judge. Prosecution is already in there, but the legal team just went into the back. Apparently they went back to the chambers. Garnett says she spoke to the defense in private just now because, while the public has a right to hear criminal proceedings, that right is not limitless. Said that their conversation, and a March 22nd letter about this, will remain sealed for now. The chambers conversation and March 22nd letter, Garnett says, concerns specifics about LM's defense strategy, hence the sealing. Judge Garnett, Ms. Friedman Anafilo, how long do you think the state case will take? Karen Friedman Anafilo, 6-week judge, Mr. Gentile, AUSA Gentile. The long questionnaire was structured about capital litigation. That is no longer a concern. Delay prejudices us. Garnett asks LM if he knowingly and voluntarily waived his right to be present at that chambers conversation just now. Yes, she follows up. You understood your right and you waived it. That's right. AUSA Gentile, we have at least one witness overseas, and in the state case, the motions have not even been ruled on yet, after the December hearing. Now to the delay request. Garnett asks KFA how long she expects the state trial to take. 6 weeks is probably what I would guess. USA Gentile, this case is ready to go. They've had 15 months to prepare. Their arguments are inconsistent. They should be able to prepare for both. Judge Garnett, I'll give you your chance, Ms. Friedman Anafilo. AUSA Gentile, look at the people outside. AUSA Gentile, the people outside, they believe that what LM did was right. Judge, whatever the interest it has generated, the trial is not complex. My concern is the jury questionnaires, and the defendant's right to be involved. Prosecutor Dominic Gentile pans Mark Anafilo for taking on an individual in state court, Harvey Weinstein. He says the defense is using the time conflicts of his new client in Weinstein to push for a delay in this case. Gentile, defense counsel should not be able to use that and rely on it, on self-related conflicts, to adjourn this trial, one that is actually ready to go. We have provided voluminous discovery. They've had that discovery for the last year. Karen Friedman Anafilo, there are defense available in the state case that are not available here. We need additional time. June 8th would be very difficult. The court in that case has expressed an openness to giving us more time, but is reluctant until you move. KFA responds, I just want to also put on the record, we try lots of cases. We always have one trial after another. The other matter that he's talking about that has literally nothing to do with this request. That trial is starting in 2 weeks. Friedman Anafilo, we are only asking for 2 or 3 months. Federal voir dire in November, trial in DEC. We try lots of cases. Judge Garnett, other obligations to other cases are not my concern. I am concerned with a fair trial here. I must consider 100 center. Judge Garnett, I don't want to be held hostage to a decision Justice Carros may or may not make. I propose, for now, to accomplish what we can before the state trial. So, questionnaire design conferral April 13th, proposal to court in May. Judge, May 11th, objections. Move up to May 18th, objections. By May 28th, I'd provide my final questionnaire. Conference June 1st rather than June 15th, at 11 a.m. Then, prospective jurors will let out in September, voir dire October 5th and trial later in October. Judge Garnett says she is skeptical of moving the trial wholesale into 2027 when the state trial has not been adjourned. I'll think it's a little bit of the tail wagging the dog. I don't have any control over the state schedule. Judge, I need to speak to the jury departments. In court questioning October 5th. But I wouldn't see you from June 1st forward. Karen Friedman Anafilo, could we go June 2nd? I have a conflict on June 1st. Judge, how about June 5th? I thought the state trial was June 8th. Judge, so June 5th. I only consider the state LM case, not any other state case. Weinstein, I will put a new scheduling order on the docket, after I speak with the jury department. AUSA, October 13th trial. Judge, October 26th or November 2nd, evidence begins. 9 commentary account adjourned. Before the adjournment, Judge Garnett, it is inevitable that in order for me to ensure that LM receives a fair trial, which must be my paramount concern, that some things are out of our control. That is the situation we are in because of the nature of these dueling prosecutions. The schedule is subject to change based on the events of the state case. Garnett added. She set the next conference for June 5th at 11 a.m. to talk jury questionnaires. Regarding his appearance, for those who want to know, he looked physically healthy, and a little tired, with a low taper fade, little shadow, was wearing his lucky long sleeve as well. Purat Freemangrababy. I understand people asking about how he looked, and that's fine. It becomes a problem when it's treated as the thing that needs focus from all that is happening.
The Luigi times, they kind of like blended in their like live tweets from like when Judge Carros made his decision of scheduling Luigi Mangione's trial in his case, and then blending the April 1st, 2026 when Luigi Mangione appeared in court on April 1st, 2026. It was a little bit confusing when I was reading the notes at 9 p.m. with my rollers in my hair. Follow me on social media, you get great things like that. But basically, I very much agree with the statement they made. I think a lot of people can relate to this that are covering Luigi Mangione's case at the best of their abilities and trying to keep all the accurate and correct information in Luigi Mangione's case. And I very much agree with this. I think other people as well that are also doing this but in their own way for Luigi Mangione's case, and I very much agree with this. So I'm gonna pop this little bit up first and then I'll go over my little notes and stuff in Luigi Mangione's case of the live tweets and things I want to bring up that are things I want you guys to keep in the back of your mind until we get the official transcripts for this day.
When it comes to updates, I stand by the fact I, and any other update account here, am not an ordinary update account, as in, I'm not here for a celebrity. So, because of that, I have to analyze what I post on here, besides the document updates, through 3 lenses. I have to see if the content benefits him, if it's proven by his team or himself to be true, and if it adds something important. Therefore, now specifically talking about individuals who claim this or that regarding him, I act accordingly to what his team said. Numerous statements about LM circulating online and in the media have been filled with misleading characterizations and outright lies. These fabricated claims come from opportunistic individuals who are seeking to promote themselves at LM's expense. This represents part of a long-standing pattern of people seeking to grift off the attention on LM by attempting to speak on his behalf, spread beliefs he doesn't share, and malign him generally, during a time when he cannot speak for himself. Thank you for understanding, guys. TLT.
The first thing that's important to note here, Luigi Mangione said yes, he does understand. He did waiver his right to not be there of a chamber conversation Luigi Mangione's legal team had with Judge Garnett, and Luigi Mangione understood, yes, he understood he waived his right to be there in person. It also comes out Judge Garnett asks how long does she think the state case will last, roughly around 6 weeks. Like we already know, the prosecution will definitely make it longer than 6 weeks. We've seen it before in the past. Also brought up in the document, they have one witness overseas and they also have one witness in the United States, but they are ready to go forward with the trial set by Judge Garnett. Prosecution argue the defense had about 15 months to prepare, but in reality, you need way more time than 15 months for this kind of thing, especially with, 2 trials going on. You need way more than 15 months. Also, it comes out in the live tweets, the prosecution are trying to use Luigi Mangione's supporters against him. Like, again, we've seen this many times beforehand, where they use Luigi Mangione's legal team against him. Mark Arcafillo, Karen Arcafillo, of them working on different cases. Again, it's what lawyers do. They have different clients, okay? They don't focus on one person, it's what they do. But basically now they are using Luigi Mangione's supporters against him. Basically, they said the supporters outside are agreeing what Luigi Mangione allegedly did was right. They didn't say allegedly, I'm just putting that here. And again, they are just using Luigi Mangione's supporters against him. And I do want to add this here. If you guys remember around April 1st, 2026, when Luigi Mangione had his hearing, going around online quite a bit where people said Luigi Mangione's supporters outside of the courtroom were chanting what Luigi Mangione allegedly did was right. In reality, that's not correct whatsoever. None of the Luigi Mangione supporters outside were chanting that. It was just basically from the prosecution saying and using Luigi Mangione's supporters against him, and just basically saying Luigi Mangione's supporters are allegedly saying what he did was right. Reality, no, that's not what happened whatsoever. Again, I've seen this multiple times in the past where the prosecution say something or they heavily imply something and then a lot of people freak out or just run wild or think that's what actually was happening. Like I said earlier in the video, like a couple of months back when the prosecution released their motion, basically they weirdly heavily implied Luigi Mangione was suicidal when that's not the case whatsoever, but people online kept thinking, oh, Luigi Mangione was suicidal when that was not the case whatsoever. And this has happened again here as well, where basically people said online Luigi Mangione supporters outside of the courtroom were chanting what Luigi Mangione allegedly did was correct, but in reality, no one was chanting. That wasn't happening. It's just what the prosecution said, basically saying and using Luigi Mangione's supporters against him. I find that kind of interesting. Why are people reading what the prosecution is saying and then misreading that and then thinking it's one thing when it's another? So again, just clearing that up. I've been noticing that a lot lately, where some people are reading things in Luigi's case instead of looking into things further and realizing, oh no, that's not what happened. This is what happened, and just see it or don't truly understand what was said and just run with it. And I'm noticing that a lot more. So I think people just need to take a step back, take a deep breath in and look at things more literally, I think anyway, especially in this case and just life in general as well. But I just want to clear that up. No Luigi Mangione supporters were chanting whatsoever on April 1st, 2026. It's just what the prosecution said on that day, again trying to use Luigi Mangione's supporters against him. I think they're just mad they don't have any supporters. But you do, you have so many. You have so many in power that support you guys. You have Pam Bondi, you have Donald Trump, you have all these other people, so many supporters. I think they're just pissed. They just don't have any, I think anyway, but they have so many. They just don't realize. I hope you understand I'm like messing around when I turn that little voice and I do sometimes. This was brought up by Judge Garnett when the prosecution said that about the Luigi Mangione supporters. Basically, Judge Garnett said, the thing we're worried about is the questionnaire with the jury selection, not the Luigi Mangione supporters outside. Yeah, obviously guys, like that's not what we're arguing. Stop arguing about other things. I know you guys aren't happy, you guys don't have supporters. Allowed, it's not what we're arguing about here. And like I said earlier, the prosecution like using everything and anything against Luigi Mangione, including his own legal team. The prosecution bring up and try to use basically Mark Ocafillo's, Karen Ocafillo's husband in this case, basically saying, oh, the reason why they want to push back Luigi Mangione's trial to 2027 is because Mark Ocafillo is involved in a different trial involving Weinstein, and in reality, no, that's not it whatsoever. Again, using Luigi Mangione's legal team, using Luigi Mangione's legal team against him. Again, they're just using everything and anything against Luigi Mangione at this point, targeting his legal team, targeting his supporters. And basically, Karen Ocafillo responds to that, basically saying they do one trial after another, you know, standard procedure, and they do lots of trials all the time. And the Weinstein case they are talking about with Mark Ocafillo's involvement, that is happening in 2 weeks, not when Luigi Mangione's trial is meant to happen. That was set by Judge Garnett. Again, it's standard procedure for lawyers to do multiple clients and have trials happening more than once, you know. And Ocafillo also brings up they do lots of different cases and they only request for Judge Carros' trial to start, and then 4 months later they'll be ready for Judge Garnett's trial, and that would happen 4 months later. And basically, Judge Garnett said it's not her concern for them having other cases and other trials. Her concern is for Luigi Mangione to have a fair trial. And I'm honestly so glad a judge has actually said that in this case. Thank you, Judge Garnett, to acknowledge for Luigi Mangione to have a fair trial compared to Judge Carro and the prosecutors and the Pennsylvania police force. This is also brought up, basically Judge Garnett is a little bit skeptical of moving her trial date to 2027 just because Judge Carro's trial date has not been adjourned, and she is a little bit skeptical to move her trial date to 2027 because of that reason. But this is brought up, basically Karen Ocafillo says, I want this to be in the record. Basically, Mark Ocafillo's trial is happening in 2 weeks. They do lots of different trials one after another and not do them both at the same time, and they want that as record. And basically Judge Garnett said she doesn't want to be held hostage by Judge Carro's decision of what he has made or has not made. She said they should accomplish as much as possible before the state case has started. So this little bit, it isn't like in the statements or what someone said in the live tweets, it's just like a little note from the live tweets that was added, basically saying time schedule will change just depending on what the state case has made going forward. I love turning on lights when I do my little setup and it looks like I'm being held hostage. So much fun. As I go, we're almost done. That was the end of my little notes and things I want to bring up that I read and noticed when I was reading over the live tweets on April 1st, 2026. Again, we will get a transcript eventually in the next couple of weeks of this day, but for now, this is what we have. So a couple documents did come out on this day as well. Basically, an official order has been put in place for the court date scheduled by Judge Carro to move from June 8th, 2026 to basically September 8th, 2026. I'll pop it up on screen for you guys.
Supreme Court of the State of New York, County of New York, Part 32X. The People of the State of New York, Order Ind. Number 75657-24 Luigi Mangione, Defendant ex-Justice Gregory Carro. 1. The amended trial schedule is as follows. Trial will begin on September 8, 2026, replacing the previous date of June 8, 2026. 2. The parties are to appear in court, as originally scheduled, on May 18, 2026 dated, April 1, 2026 Justice, Supreme Court.
Basically them just saying, no, we won't move it to 2027 just because, you know, we don't want to, but we understand your issues and problems, but we are only going to move Judge Carro's court date by a couple of months, not, you know, moving it or making it this fair. Very annoying and very frustrating, honestly. Normally I would keep this bit in like the section of like things that aren't really relevant in Luigi Mangione's case, but like things I want to talk about, but I thought this was incredibly important. So basically a Redditor noticed, I think they were there on the day, basically noticed one of the prosecutors were actually lying on the day of like every single thing they were talking about, and basically were lying, and I find it incredibly interesting. Please take it with a little bit of skepticism, but I do think it's very interesting, and I'm surprised not many other people also notice it as well, so I'll pop it up on the screen for you guys.
SDNY Assistant Attorney Gentile lied about discovery in court case discussion. I noticed something interesting during the federal hearing today. Assistant U.S. Attorney Dominic A. Gentile was lying about discovery provided to LM's team. The prosecution brought the matter up twice. This case is ready to go. They've had 15 months to prepare. Their arguments are inconsistent. They should be able to prepare for both. Defense counsel should not be able to use that and rely on it, on self-related conflicts, to adjourn this trial, one that is actually ready to go. We have provided voluminous discovery. They've had that discovery for the last year. LM's attorneys were hired 15 months ago. They were not given 15 months to prepare. It is also untrue that they've had the entirety of discovery for the last year. KFA has repeatedly mentioned in motions, both state and federal, that evidence has been withheld from them. Motion filed in the New York State case on March 21, 2025, while Gentile is a federal attorney, and the argument today was about the federal case. It is the NYPD, and consequently the Manhattan District Attorney's Office, that handled and handed over the bulk of the evidence, as Joel Sederman cannot shut up about. As per KFA's motion, despite this clear requirement, the defense has yet to receive any civilian witness discovery. While discovery provided thus far is voluminous, it is far from complete and, most notably, it is missing essential records that are in the prosecution's possession and are necessary for defense motions. For example, the prosecution has yet to provide the defense with any non-law enforcement discovery, including civilian grand jury testimony and NYPD DD5S. In addition to civilian witness records, the defense has also not been provided with access to, or copies of, the information contained in the electronic devices alleged to have been recovered from Mr. Mangione to date. The district attorney's office has not yet turned over the civilian witness testimony in the grand jury, or a copy of the numerous electronic devices that law enforcement had seized from Mr. Mangione, including several USB flash drives, a computer chip, and a laptop. This has left the defense in an untenable position where it must challenge the sufficiency and appropriateness of the grand jury proceeding without having all the grand jury evidence, and decide whether to challenge the warrants surrounding electronic devices without knowing the contents of these devices. Moreover, some of the withheld civilian testimony pertains specifically to the terrorism enhancement that is the basis for the indictment's first-degree murder charge and one of the second-degree murder charges. Without this testimony, counsel simply cannot challenge the sufficiency of the grand jury minutes as to these serious charges. In addition, the prosecution has not provided counsel with any information or documentation that it received from the federal government as part of the joint NYPD-FBI investigation into Mr. Mangione. This is not a parallel investigation nor prosecution, as this case involves one set of facts, and the state and federal cases rely on the same evidence. Despite the joint nature of the investigation and prosecution, the district attorney's office has not provided counsel with any information it received from federal law enforcement as required. Arraignment in the federal case on April 25, 2025. Judge Garnett acknowledges all evidence has not been handed over. See page 9 of transcript. I'm going to order the government to produce all discovery in their possession within 30 days of today, which is, given the holiday, I'll say by Tuesday, May 27th. Judge Garnett orders the prosecution to hand over all evidence, including material favorable to LMC order. The government must disclose to the defense all information favorable to an accused that is material either to guilt or to punishment, and that is known to the government. Omnibus, filed in the New York State case on April 30th. 2025. Please see pages numbered 14 and 36 in the motion. To date, the District Attorney's Office has produced more than a terabyte of information in discovery. Notably, the District Attorney's Office has withheld additional discoverable materials, including portions of grand jury testimony. The defense has not been provided with the full grand jury transcripts. Thus our arguments are based on the transcripts provided. Reply filed by KFA in the New York State case on November 11, 2025. She challenged the prosecution's statement of compliance, aka their official acknowledgement that they have disclosed all the evidence. As part of the counsel's October 21, 2025, motion to invalidate, we noted several issues with the KAF, that 2 files were provided in an unreadable format and that the people had not provided information or documentation related to a missing person report filed by the Mangion family in San Francisco regarding NYPD Chief of Detectives Joseph Kenny's statement to the media about Kathy Mangion allegedly saying this about her son. She said she could see Luigi doing something like that to date. There has been no documentation provided in discovery that confirms the Chief of Detectives' statement as to Mrs. Mangion's alleged statement. KFA said she was going to challenge the KAF as late as December 18, 2025, during suppression hearings for the New York State case. The prosecution never actually handed over any documentation explaining why the death penalty was sought in the first place, though thankfully that is not needed anymore. LM's team clearly hasn't had that discovery for the last year, as Gentile says, much less a full 15 months to prepare. Not to mention that Carros is set to rule on suppression on May 18, 2026. That's 3 weeks before trial is due to start.
Here's another screenshot from courtlistener.com of information that came out on this day, so I'll pop it up on the screen for you guys.
Oral Order Status Conference Minute Entry for proceedings held before Judge Margaret M. Garnett. Status Conference as to Luigi Nicholas Mangion held on the 4th of January 2026. Status Conference held. Defendant appeared with attorney Jacob Kaplan, Karen Anafilo and Mark Anafilo, AUSA Dominic Gentile and June Zhang present for the government. Court reporter present. The parties are to confer and provide the court with an updated schedule for pre-trial materials. Speedy trial time excluded until November 2, 2026. Detention continued. BW, oral order as to Luigi Nicholas Mangion. Time excluded from the 4th of January 2026 until the 11th of February 2026. BW.
Another thing I do want to add here, I'm honestly quite surprised. I think this has been the most quiet court appearance from Luigi Mangione I've ever heard in this case lately. I think maybe everyone just got tired a little bit just because, we did not get many live streams of when we saw Luigi Mangione walking down the hallway compared to in the past, but we did get lots of photos around that time of Luigi Mangione. But I think a lot of the hype sadly died down because literally this has been the most quiet time I've ever heard of Luigi Mangione's case, of Luigi Mangione appearing in court, than I've ever heard before in the past. Like, I saw the die down slowly surrounding Luigi Mangione's case ever since September. It's crazy and kind of sad, I think, anyway, but like literally nothing in this case when Luigi Mangione appeared in court on April 1st, 2026. The 2nd of April 2026, this is a order submitted by the United States government, so I'll pop it up on screen for you guys.
United States District Court, Southern District of New York, United States of America v. Luigi Nicholas Mangion, 25 CR 00176, MMG, Scheduling Order Defendant, ex Margaret M. Garnett, United States District Judge, in light of April 1, 2026. Decision in the defendant's state court case to adjourn the state trial to September 8, 2026, and the discussion held with the parties at this court's earlier April 1, 2026 conference. The court orders the following schedule for trial in this matter. The schedule retains the original February 3 order dates for decisions on the content of jury questionnaires, and sets out the remaining relevant dates for the trial discussed at April 1 conference. In addition, defendants' counsel remain obligated to provide the court with an ex parte status letter on April 24, 2026, as discussed at the ex parte conference on April 1. The court will not entertain any further applications for adjournment of the trial schedule set forth below prior to receiving that letter. Finally, all counsel are ordered to remain available for in-person voir dire beginning January 5, 2027, and trial beginning January 25, 2027 through February 12, 2027, unless and until otherwise ordered by this court. Should a further adjournment of the trial become necessary, April 13, 2026, parties to exchange proposed jury questionnaires and confirm a 4th, 2026, parties to submit their proposed questionnaire, to the court. The form of the proposed questionnaire should be 1. One document that contains the agreed upon questions, and 2. A document submitted by each party with any additional questions that party is requesting. All 3 documents should also be emailed to the court in a Microsoft Word format document to Garnett NISD Chambers at nisd.escourts.gov on May 11, 2026. Parties to file objections, if any, to each other's proposed questionnaires May 26, 2026. Oppositions to objections due June 11, 2026. Court to provide proposed final questionnaire to counsel June 15, 2026. Conference at 11 a.m. to discuss final questionnaire and jury selection process August 14, 2026. Government to disclose any expert witnesses to defendant, pursuant to Rule 16, 1, G September 8, 11, 2026. Jury Department to administer written questionnaire to prospective jurors in a venire of approximately 800. Government to scan completed questionnaires each day and provide to the court and defense counsel September 11, 2026. Defense to disclose any expert witnesses to the government September 11, 2026. Parties proposed voir dire for in-person jury selection due September 18, 2026. Parties to exchange lists of jurors to be struck for cause based on questionnaires alone and lists of jurors that require follow-up questioning regarding questionnaire answers September 23, 2026. Parties to confer and submit a list to the court of jointly stipulated proposed strikes for cause and joint proposed list of jurors who require follow-up questioning regarding their questionnaire answers, as well as separate lists, if necessary, of any additional jurors that only one side seeks to strike for cause or requests follow-up questioning September 25, 2026 at 11 a.m. Conference to rule on stipulated and requested strikes for cause. List of venire for in-person questioning finalized and provided to Jury Department for notification regarding in-person voir dire October 2, 2026. Motions in limine due, including any Daubert challenges, Tuesday, October 13, 2026 at 9:30 a.m. In-person voir dire begins, October 16, 2026. Oppositions to motions in limine due. The court generally does not permit reply on motions in limine October 23, 2026 degrees. Proposed requests to charge and verdict form due Friday, October 30, 2026 at 11 a.m. Final pre-trial conference, Wednesday, November 4, 2026. Opening statements. The presentation of evidence begins. The proposed voir dire, proposed jury instructions, and proposed verdict forms must be emailed, in Microsoft Word format, to so-ordered. Dated, April 2, 2026 New York. New York Marga Garnett, United States District Judge.
Basically, this is a official document by Judge Garnett, basically showing the pushing back Judge Carros' trial date for Luigi Mangione, not by much, but by a couple of months. Honestly, when I saw this, I was fucking infuriated. It was very annoying and very frustrating, honestly. I've been also noticing this as well. Some people have been getting confused between the trial dates set by Judge Carros and also Judge Garnett. I think it's because they're very entwined at the moment, and I think some people are getting a little bit confused. I've noticed that quite a bit, and I've been talking to other people online about this, and they've also been noticing this as well. It's okay, I'm like, I get confused with this stuff too, so don't worry. But that's why I'm here. I'm combing through it with a little comb so I can break it down for you guys, so you know what's what. It's also brought up in this document on April 24th, 2026. They will be expecting a letter just explaining the entire situation. I'll be definitely covering that in my next video, going over updates in Luigi Mangione's case. It's probably going to happen in the next couple of weeks or so. So again, I will cover that. And they are expecting a letter to explain the entire situation of the scheduling conflict. And it also comes out Judge Garnett isn't going to adjourn her trial date for Luigi Mangione, but she is keeping January 2027 for a trial date as backup. I do like she is considering it as an option, but not right now. Like I said earlier in the video, normally I would leave this bit into the part of the video that aren't really relevant to Luigi Mangione's case, but I still want to talk about it anyway. But I thought I should put this here anyway, just because, you know, Pam Bondi decided to get involved and put her hands into Luigi Mangione's case when she wasn't meant to whatsoever. Basically, on this day, Donald Trump decided to fire Pam Bondi and basically get rid of his lapdog, and oh my god, everyone was very excited hearing that news. Now, I actually did read the article and reading what actually happened. So basically, technically, she hasn't been fired, she's just been moved to a... Technically, Pam Bondi hasn't been fired, she was technically moved to a different department that's secret, and basically a lot lower ranking position than what she had, but at the moment, Donald Trump has hired another person to be his district attorney and basically being his lapdog again until they find a new replacement to be his district attorney. And basically, it honestly sounds like she's been fired but not really fired. You know that thing in Japan where they don't fire anyone, but they will demote someone so far until they want to quit so the company looks good? I feel like that's technically is what happened with Pam Bondi. They haven't fired her, but they've moved her into a position where she would probably want to quit and basically is fired, if that makes sense. And another thing that also came out on this day, Luigi Mangione will appear in court on the 18th of May 2026 for Luigi Mangione. He will appear in court again on that day, the 7th of April 2026. Basically, this document came out literally right in the middle. I was writing this script and I was gonna, like, you know, ready to film and stuff, and then this document came out. Basically, this document is just saying they are requesting for the transcript to be released to the public what came out on the 1st of April 2026. So hopefully that will come out in the next couple of weeks. I'll definitely make it its own dedicated video, so I'll pop it up on screen for you guys.
In the United States District Court for the Southern District of New York, USA/Plaintiff, S. v. Case No. Defendant, S. Notice of filing of official transcript notice is hereby given that an official transcript of a held on has been filed by the court reporter/transcriber in the above captioned matter. Redaction responsibilities apply to the attorneys of record or pro se parties, even if the person requesting the transcript is a judge or a member of the public or media. The parties have 7 calendar days from the date of filing of this notice to file with the court any notice of intent to request redaction of this transcript. A copy of said notice must also be served on the court reporter. If no such notice is filed, the transcript may be made remotely electronically available to the public without redaction after 90 calendar days. This process may only be used to redact the following personal data or identifiers: social security numbers, dates of birth, minors' names, and financial account numbers. See Federal Rule of Civil Procedure 5.2 and Federal Rule of Criminal Procedure 49.1. Parties wishing to request redaction of other information may proceed by motion. We certify that the foregoing is a correct transcript from the record of proceedings in the above entitled matter.
Okay, so that is the end of all the updates in Luigi Mangione's case as me filming this video, the 13th of April 2026. And now we are going to be moving on to things that aren't really relevant to Luigi Mangione's case, but I want to bring up anyway, and also that little article I brought up earlier with Karen in it. I probably had a lot of things that aren't really relevant in this case, but kind of in that moment in time are relevant in this video more so now than ever, and also my final thoughts in this case. So this is basically the article that came out on with Karen Ocfillo, so I'll pop the article up on screen for you guys.
Karen Friedman Anafillo, a former prosecutor, is in the spotlight defending Luigi Mangione Grace Rivera / for the Washington Post by Shana Jacobs yesterday at 7 a.m. EST. Having someone's life in your hands, literally, is a weight that I've never felt before, said Karen Friedman Anafillo. As Luigi Mangione's defense attorney, Friedman Anafillo is now engaged in protracted legal battles with state and federal prosecutors over indictments against Mangione for December 4, 2024, fatal shooting of United Healthcare CEO Brian Thompson in New York City. The veteran attorney, her husband Mark Anafillo and their co-counsel Jacob Kaplan say prosecutors unfairly saddled Mangione with 2 murder cases and enhanced charges because of the publicity his case received. Both cases were downgraded in recent months. In late January, a federal judge effectively barred the Justice Department from pursuing a death penalty case. State-level terrorism charges against the Baltimore native were dismissed after Friedman Anafilo and her team argued they did not legally apply. This is not the first time Friedman Anafilo is at the helm of high-profile, headline-grabbing criminal matter. As second-in-command and in other roles at the Manhattan District Attorney's Office before she left public service in 2021, the office prosecuted several high-profile individuals including Harvey Weinstein. Friedman Anafilo had to recuse herself from a case that went to trial in 2020 because her husband's former law firm, at one point, represented Weinstein. After she left the office, Friedman Anafilo was a frequent commentator during the hush money case against Trump because of her legal experience. Far from seeking a career in law enforcement, Friedman Anafilo was most inspired by the time she spent working with Washington, D.C., inmates as a law student. Those prisoners were so much more than the act they committed but were not getting meaningful education, job training or a true chance at rehabilitation, Friedman Anafilo said. As a prosecutor, Friedman Anafilo helped to install a variety of programs aimed at rehabilitation for defendants and assistance for crime victims and their families. She also secured funds to conduct DNA testing of the nation's backlog of rape kits and launched mental health treatment court in Manhattan, where she personally attended participant graduations. There's nothing better than going and handing someone a diploma, hugging them, cheering them on and celebrating their life, Friedman Anafilo said. While she is most proud of her work on those initiatives, her time as a prosecutor also primed her for the attention blitz that arrived when she took on Mangion as a client. I feel like I've been playing Major League Baseball for a very long time, Friedman Anafilo said.
So that was the end of that little article. Again, it will be linked on the website with the screenshots and yada yada yada. I said this earlier in the video, but basically the screenshots will be up on the website if this Reddit post gets deleted, because that does happen sadly on the internet. I will put the screenshots there and also the link to the Reddit post as well with this article if you want to go read it. It's very interesting. Again, like I said earlier, we don't really get many articles or interviews with Luigi Mangione's legal team, but I think it's kind of smart of them not to do so because one, they're busy being lawyers, and two, like we already know, the media loves twisting things, what everyone says. Like we saw what Luigi Mangione's mum said, to the media heard that and then twisted it again, like we already know. So it's smart for them not to do that. So this is another article I recommend to go read. This is by a Luigi supporter. They are a journalist basically, and they are from Italy, trying to spread a word around about Luigi Mangione's case in Italy. I recommend it. It's very interesting to read. It isn't biased or anything compared to like every article we have surrounding Luigi Mangione's case, so I do recommend to go read it. By the way, this person is also on Instagram and TikTok. They are called Italians for Mangione. I do recommend to go follow them. They do really great stuff and all that, so I do recommend it, and also go read this article. So again, I'll pop it up on the website if you want to go read it and stuff. I am seriously considering making a little section on my website of articles people recommend to read, and I recommend you guys to go read it because you guys are slowly sending me a lot more articles than I can catch up and read, but they are very interesting. So again, I'm slowly considering that as an option. I will get the paid version of Wix one day. At the moment, I need to save. Okay, so now we're going to be moving on to my little final thoughts of what's going on in Luigi Mangione's case at the moment. I don't really have that many. I think I spread majority of my feelings about this case in my last video because again, I'm doing this back to back, but basically it's honestly bluntly obvious double jeopardy is going on in this case, and they're making it so goddamn hard for Luigi Mangione and his legal team to have a fair trial, and it's basically just been a game of tug-of-war between the state case and the federal case in Luigi Mangione's case, and it's bluntly unfair and obvious. And honestly, if you guys follow me on social media and you're I read the documents when they first come out, you can see how goddamn mad I get. I'm like so angry, filtering myself from like my notes. Like there's a lot more swearing and anger in my notes than I'm letting off here, because you know, I want to be calm, collected, and giving you guys information. Sometimes I'm just mad on that day and I'm just angry through my entire notes and stuff like that, and I can't control myself. My personal opinion about it is, I think the prosecution want this done and dusted as quick as possible, so basically people won't pause and think and look into things further and seeing all the holes that are forming and forget all the dodgy, sketchy shit they've been doing ever since the beginning when Luigi Mangione was arrested. In this case, to get this done really quickly, people like forget and ignore it and not see things, instead of, you know, looking things into further if this happened a lot longer, and people would like think about things a lot longer. It's like, oh yeah, that doesn't make sense, what's going on, if that makes sense, compared to if they did this really quickly, if that makes sense. But basically, double jeopardy is 100% going on, and this entire case has been bluntly unfair towards Luigi Mangione ever since those officers stepped into that McDonald's, and it's bluntly unfair. And they're making it so goddamn hard for Luigi Mangione to have a fair trial, and it's bluntly obvious. So basically at the moment, it's just a game of tug-of-war at the moment in Luigi Mangione's case, and it's so unfair and it's bluntly obvious. That's really it. That's like, I'm just really annoyed at the moment in Luigi Mangione's case because of the double jeopardy that's obviously going on. Honestly, my massive anger at the moment is just with YouTube at the moment. Why did you guys take down my personal channel? I literally make 3D printing anime figurines and cute vlogs I made when I was like, you know, 23. Anyway, so I'll spend the next couple of weeks organizing that stuff. Just gonna be making audio versions of those like 50 plus pages documents that I mentioned in my last video, so that's going to be coming out in the next couple of weeks. Also maybe like a bonus video. Soon it's going to be like a full year of me making these videos, and a lot has happened honestly in the span of like 2 months honestly on this channel, and also like a year or so. So I think I might make a little fun bonus video. I'm not sure what it is yet. I'll make something, but I know a lot of YouTubers celebrate them getting 1,000 subscribers. Today I watched a video of one of my YouTubers I really enjoy watching. They've been on YouTube for 5 years and they do that little anniversary thing, so I think I might start doing that too, just like, you know, a fun little bonus video of me just being here for a full year. And also, I really enjoy making these videos. Stopped doing it for a month, I realized, wow, I hate not doing these. So I don't know why, but making these silly little videos talking about Luigi Mangione's case and other things happening around the world that I think that are incredibly important that people should talk about do give me this little feeling of like purpose for some reason, even if I know that sounds quite silly. But I'll spiel about that in my little anniversary video of me doing this for a year. So again, I don't know what I'm gonna do for that, but like, I'm gonna do it just for funsies, you know. So expect that in the next couple of weeks of me making a little bonus video celebrating me being here for a full year for fun, honestly. Hope you guys enjoyed this week's video. I hope you enjoyed it, but again, sorry this video came out a lot later than expected. Life happened, things took a lot longer than expected. My microphone broke. I got a brand new microphone. That took longer to find because I had to go on a little bit of a field trip because these are on special right now and everyone wants to get one. So I will work out how to decorate this because I don't want a boring white ass microphone, even if it's kind of pretty. But I miss rainbow microphone, you were fun. So I'll figure out how to decorate this in a cheap way and maybe make a tutorial for other people that want to do that too. This is fucking heavy, oh my god. Am I gonna end up super jacked? This microphone's so heavy. I think it's the base though, oh my god. Thank you for watching this week's video. You can subscribe if you want to, it's okay if not. I upload 3 times a month, and if you guys want to keep up to date with the channel, you can follow the channel's social medias. That'll be in the description down below. And if you want to follow me personally, all of my social medias are in the description down below. Bye! Did my elbow just crack? I'm 25. I'm aging rapidly. Okay, bye.